Representative, please go ahead. Representative Ottman. Privilege of the floor, please proceed.
Privilege. Thank you, Mr. Speaker. In your cubbies or your mailboxes, you will find a little blue cup like this along with some information. The information is from the Job Corps organization. We have one here in Wyoming. It is open to students right now because of all the things that have gone on the last couple years. There is a 75% occupancy availability. So please look at the information. And there's some for the families, some for the students, and some for potential employers. They have a twofold mission: one to help youth, to make a skilled workforce that can support the needs of U.S. business and industry, and two, to help youth break a cycle of poverty with a bright future and a good paying career. So please look at that and see if it's not in competition with anything that we're doing here. It's just to help the Wyoming families possibly in another way. Thank you.
Thank you. Representative Heiner, privilege, please proceed.
Thank you, Speaker, for the privilege. Members, I'd like you to look to my left up here. There's a man from Green River, Wyoming, our mayor, Pete Rust. I'd like you to welcome him to the chamber. Pete, stand up. Mayor Rust, I believe, was born in South Africa, weren't you, Mayor? We import them from a long ways.
Chairman Zwanitzer,
Privilege of the floor.
please proceed.
Thanks. Members, first, thank you for the about 15 of you who showed up over lunch quickly for a impromptu award ceremony for my intern, Grant Baxter, up there in the North Gallery. Out of 86,000 students, high school students, who applied for a Coca-Cola scholarship, Grant was one of the 150 awarded a $20,000 scholarship, and one of the 5 students that the camera crew came all the way from Nashville to award in a surprise announcement at noon. So please congratulate Grant on $20,000.
Congratulations, Grant, and welcome to our Green River friends. Any other privileges? We've still got, I think, maybe a committee out. We seem to be missing a few members, but we have an amendment on the next bill, so we'll march on. Next bill for our consideration is House Joint Resolution 6. Reading clerk.
House Joint Resolution 6, sponsored by Capital Financing, Common School Account, Investments and Distributions. A joint resolution proposing to amend the Wyoming Constitution to modify and modernize the Common School Account within the Permanent Land Fund.
We have an amendment. Representative Baer.
Thank you, Mr. Speaker. I move third reading amendment number 1 to House Joint Resolution number 6 and ask for your favorable consideration. So, ladies and gentlemen, we just debated this exact same issue before we went to lunch. Hopefully, lunch didn't make you forget any of those details, because these are the same details. The difference is we're talking about the school foundation program now. So this is where we save our money, we get revenue off of that investment on those saved dollars, and it goes to school foundation. The only thing I'm going to add to the discussion we had earlier is what I read in our budget data book on page 9, and if you want to access that online, it is available from the homepage under State Finances. Page 9 of that revenue book says this: the LSO completed a crude analysis of Wyoming's revenue volatility in 2014. They found it was as high as 30% for the school foundation program. Looking back at the other program that we just debated, it was 14% for the general fund and BRA. Now, Pew Research looked at it a year later, and they confirmed that the LSO's calculations of 30% volatility was accurate. So I bring this up because this is how we fund our schools. This is going to be funding our schools for many years. And the policy that we debated just before lunch is about making the corpus more available for spending. That's where the revenue is coming from, is the investment of that corpus creating a return. So we're allowing ourselves to dip into that, and we're talking about school funding. So with that, I just would ask that you'd rethink this on the school side and come with me on this amendment.
Thank you. Representative Stith, first time.
Mr. Speaker, I voted no on the one previously, and I wanted to give the sponsors an opportunity to address an issue that I don't think we quite fleshed out, which is by putting the 5% spending policy amount cap, essentially, in the Constitution. Can you explain what the effect of that would be during a period of high inflation? And here's what I mean. If you had 5 years of 10% inflation and the underlying assets, say, growing at a 5% rate of return, then because the spending policy amount is 5% now set in the Constitution, the effect of the inflation is to skew the actual amount of the 5%, the hard dollar amount, with the result that if you have 5% return on your investments for 5 years with no inflation, then 5% of your rolling average turns out to be 4.5% of your last year. Just how the numbers work. But if you have 10% inflation along with your 5% underlying growth, then you're at the end of the 5 years, the amount you're allowed to spend is 5% of the average. And as a result, it's only 3.6% of your most recent year. So the result is that the actual money you get, instead of being 4.5% of your most recent year that you're allowed to spend, it would only be 3.6%. You've lost almost a full point. And that's, a lot of money, right? That's for this fund, that would be approximately $35 million that you don't get, because you'd have in the Constitution be getting much less than the 5%. So just wanted to ask the sponsors to sort of address the effect of inflation and whether this proposed amendment is too rigid to deal with that.
Madam Minority Floor Leader, first time.
Thank you, Mr. Speaker. On and against the amendment and for the bill. And friends, I want you to keep in mind the question that was just asked by the very smart attorney from Southwest Wyoming. All right? So keep that in mind because it honestly makes my point. The good former speaker, who was the former chair of appropriations, gave us a tutorial. And he lifted up that invisible, right now it's invisible, right? Kind of sheet of paper and a line down it. And I very much appreciated it. All right, that made a lot of sense to me. And I've been around here for a long time. But there was one sentence that he had in there that I disagreed with. And that was, hey, this is easy, right? The language of the amendment to go on the ballot is easy right now. Let's just vote for it, right? That's the sentence I disagree with. And I disagree with it because of my experience with having been a legislator when we had Amendment A on the ballot. That right there simply allowed the treasurer to invest some funds differently. And I'll tell you that every time I spoke in public, both in my community as well as around the state, I was asked to explain Amendment A. I needed to know every sentence, every clause in Amendment A for folks to understand it, and they really wanted to understand it. And I was able to do it, and I was able to do it in a way that folks understood. It seems to me, from the last vote on the last joint resolution, we honestly think it's a good idea. It is, it's a good idea. And if a few of you have thought over lunch, but you know what? Honestly, the good bringer of the amendment had some points about a 5% cap on a 5-year rolling average with quarter-point increments to be voted on by 3/4 of the body might make sense. In all honesty, I couldn't explain that to folks. I couldn't explain that to folks and make it meaningful for them in order to vote for a constitutional amendment. We are getting so much in the weeds at that point that it makes it too confusing for folks to vote yes, all right, on a change to our Constitution when they know our investments are so important. All right, so that's why I think we should vote no on this. I totally agree that there are elements of this amendment that make absolute sense. But some of it, quarter increments, a third increments, half increments, they could make sense as well. But I want you to think back to the question by the former legislator speaking at the microphone, because those are the kinds of questions that you would get from constituents. They're reasonable questions, right? But that, I think, is for us in this body via our statutes to decide, right? What we want, all right, our residents, our constituents to vote on is an investment policy that will get us the most gains in the state from the investments that we have right now with our inviolate accounts. And that's what the joint resolution does without the amendment. So against the amendment and in favor of the House joint resolution. Thank you.
Any other members, first time? First time. Chairman Harshman, first time on the amendment.
Thank you.
Joint Resolution 6.
Briefly, on against the amendment members, and I appreciate the good member from the Campbell County bringing up the volatility piece on page 9 of our data book. And we know, obviously, schools are the most volatile because they're funded with property taxes, and primarily like every other state. And the issue in Wyoming is minerals pay most of our property taxes, and they're valued at 100%, not 9.5 like our homes. So it's a interesting piece that we ride up and down that piece. But I just wanted to make sure that there was no confusion, because we talked about this in our CapFin subgroup. And it doesn't say in the Constitution that the common school account is inviolate. Doesn't say that. And we talked about we should put that word in there because the permanent mill trust fund says inviolate. But if you look on page 2 of this joint resolution on the original Constitution language, and this goes back to 1890, right? On lines 9 and 10, Article 7, Section 2, because I asked that very question. And they said, no, the attorneys for us that work at LSO said the word perpetual means the same thing, and to leave that be. So we left it be under advice from our attorneys. So the following are declared to be perpetual funds for school purposes. So we're not going to dip into the corpus. In fact, this amendment says we will make any losses to the corpus whole. That's a big deal. So against the amendment, and please vote for the joint resolution. Thank you, Mr. Speaker.
Thank you. Chairman Nicholas, first time.
Thank you, Mr. Speaker. So, ladies and gentlemen, on and against the amendment, I mentioned it earlier this morning. So we've got the permanent fund, and then we have the Common Schools Permanent Fund. So the Common Schools Permanent Fund is currently managed a little bit differently by our investment folks because it relies more on income. And so when you look at the total return right now, or in the past 10 years of the permanent fund versus the Common Schools Fund, the Common Schools Fund makes less money, which is interesting because really in common schools, we need more money. So this amendment is actually more important for the common school account than the permanent mental trust fund, because this is the fund we definitely need to go to a total return versus an income-based model. And so, once again, I please stand on your vote from this morning, because this is where we need it the most. Thanks a lot.
Any other members first time? First time, first time. First time, second time to the sponsor. Representative Bear.
Thank you, Mr. Speaker. It's a pretty simple thing. Protect the corpus. That's what this amendment does. On
All right, members, we are voting on third reading amendment number 1, House Joint Resolution 6. All those in favor, please say aye. Those opposed, no. The amendment is not adopted. House Joint Resolution 6, having been read 3 separate times, the question is, shall the bill, joint resolution pass? Requires a 2/3 vote. Chief Clerk, please call the roll.
Andrew, Baker, Banks, Bear, Blackburn excused, Brown, Burkhart, Burt, Clausen, Connolly, Crago, Duncan, Eklund, Ayer, Flitner, Fortner, Gray, Greer, Hallinan, Haroldson, Harshman, Heiner, Henderson, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, LeBeau, McGuire, Nyman, Newsom, Nicholas, Oakley, Obermuller,
Aye.
O'Hearn, Olson, Ottman, Paxton, Provenza, Rodriguez Williams, Romero Martinez, Roscoe, Schwartz, Sherwood,
Aye.
Simpson, Summers, Stith, Stivar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zawanitzer, Mr. Speaker, Roscoe. Closing vote. Are there any changes? Closing vote. The vote is closed. 45 aye, 14 no, 1 excused.
House Joint Resolution 6, having received a 2/3 majority vote of the members elected to the House, House Joint Resolution 6 has passed the House. Representative Newsom,
Privilege of the floor.
please proceed.
Thank you, Mr. Speaker. Up in our South Gallery, although you may not be able to see them because it's camo in the Capitol Day, are our friends from Wyoming Wildlife Foundation, and a great bunch of people, anglers and hunters from all over the state. And they are here to learn more about legislating, more about advocating for hunting and angling. I do want to recognize my dear friend, Rob Coe, nephew of Hank Coe.
welcome to the House. We hope you enjoy your stay. Thank you for being here. So members, as you know, tomorrow is third reading on the budget. 5 p.m. this afternoon is the deadline to turn in your budget amendments. And recall that approving them is 2 hours prior to convening. At this point, I think the discussion is we'll probably convene tomorrow morning at 9:30. So that means by 7:30 tomorrow morning, whenever the adjournment announcement is made, you'll know for sure. But 7:30 tomorrow morning, I would suggest you have approved your budget amendments for third reading tomorrow. Third read, and then as you know, we will have, we're going to do committee of the whole today, and we'll take a look and see how many bills we get through. We may try to knock them out on second reading and go to third reading on the budget tomorrow. So, I mean, we will do third reading on the budget tomorrow. We'll see whether we get to second reading depending on how the committee of the whole goes today. So, any announcements from the body? Any announcements from the body? Chief?
Speaker.
Chairman Eklund, please.
I think it's appropriate to do this now. So during my committee meeting this morning, I accomplished a technical glitch, imagine that, but it can be fixed. And I'd like for my committee to meet upon adjournment to reconvene, the Ag Committee, to reconvene on our reconsideration vote so that I can get it right this time. And it'll be right upon adjournment in the Supreme Court chamber, and we'll have help to make sure we get it right.
So remember, just so we're clear, the Ag Committee is going to convene upon adjournment in the Supreme Court room. There was a reconsideration on the bill, and the reconsideration vote was taken, but not the vote on the bill. So it's just an oversight, and the committee would like to rectify that and forward whatever their action is to the body. So, Chairman Harshman.
Thank you, Mr. Speaker. Your committee number 3 has found a home for our meeting on adjournment for House Bill 147, and that'll be in West Conference Room 113. 113. Thank you.
So that's the West End on the first floor. Madam Minority Floor Leader,
Speaker of Privilege.
please proceed.
Thank you. Friends, could you help me in welcoming in the West Gallery a member of our City Council, Aaron O'Doherty.
Welcome, welcome. My presumption is our city council means Laramie, but thanks for checking. Thank you for being here. Any other announcements? Any other announcements? Mr. Majority Floor Leader.
Mr. Speaker, thank you. And before I make the motion to resolve into Committee of the Whole, so just an update on Committee of the Whole. So tomorrow is the last day for Committee of the Whole in the House of Origin. We have third reading of the budget tomorrow. The odds of us getting much of any, well, depending on what you all do with your budget amendments, including myself, whether we have any or not. So think about that as we work Committee of the Whole today. I do not intend to go past about 6:30 tonight. And so this very likely could be it. And so just on a note, remember the first 10 bills on your general file list are Committee of the Whole, and then I will provide the next 10 after that. Okay, with that, Mr. Speaker, I move that the House resolve itself into Committee of the Whole.
You've heard the motion. All those in favor, please say aye. Those opposed, no. Representative Brown.
Committee of the Whole, please come to order. The first bill for our consideration is House Bill 73. Reading clerk, please read the bill.
House Bill 73, sponsored by Select Water, Omnibus Water Bill Planning, an act relating to water development projects. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom was referred House Bill 73, Omnibus Water Bill Planning, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Blackburn, Clausen, Eklund, Fortner, Heiner, Larson Dan, Western, Wharf, Winter. Representative Eklund, Chairman. This bill was re-referred to Committee number 2, Appropriations. Mr. Speaker, your Committee number 2, Appropriations, to whom was referred House Bill 73, Omnibus Water Bill Planning. Respectful report, same back to the House with the recommendation that it do pass. Ayes, Representatives Kenner, Larson Lloyd, Nicholas, Schwartz, Simpson, Stith. Representative Larson, Vice Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Eklund?
Mr. Chairman, I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill number 73 do pass, and I turn the explanation over to the Chairman of Select Water.
Representative Simpson.
Thank you, Mr. Chairman. You know how I love to talk about water projects, so let's get going. This House Bill 73 is the 2022 Omnibus Water Bill associated with planning projects. On your desk this morning, there was a blue spreadsheet. Hopefully, I'm going to give you a chance to find that while I'm talking along. In fact, once you find it, just start studying it, would you please? So here's the process. In March, the Water Development Office receives applications from municipalities and irrigation districts that are having challenges with their water systems. And they send a staff engineer out, they evaluate the project, they come back and report to the Water Development Commission, who then considers all the applications and the criteria, and the ones that qualify to be advanced are then, a scope of work is written up. They actually interview consulting engineers and select them with hard numbers, and the hard numbers are then placed in our bill, and the projects are placed on hold until we approve them. And so here's the bills, or the projects in front of you. The blue spreadsheet is a summary of what you find in the bill. So I'm not going to go over all the projects today, folks. You've been down this road before, you understand what this is all about. So in the interest of time, I'm going to hit a couple key highlights that are important for you to know. Across the top heading of the spreadsheet, you'll see the initials WDA1. That stands for Water Development Account Number 1, Water Development Account Number 2, and Water Development Account Number 3. Water Development Account Number 1 is new development, new sources looking for new water. Water Development Account Number 2 is rehabilitation of existing projects. And account number 3 is dams and reservoirs. So as you glance down through the spreadsheet, you'll see projects there on the left, the location, the county they're located in, and the allocation, the money resources associated with that particular project. And then on the far right tells you a little bit more about what's there. The Select Water Committee has studied every one of these projects in detail and are recommending approval to you today. All the projects are relatively standards, but there's except two, they're noteworthy. So drop down on the far left, you'll see tab number G. So on the construction bill, we consistently bring to you cloud seeding projects under the construction bill. And you consistently ask us, can you prove to us that the cloud seeding is working? And we now have 4 years of data. And so the Select Water Committee has asked the Water Development Office, can we now do analysis to document that what we're doing, the investment, is returning actual water in the streams? And so they're responding with that. That's $300,000. And they now have stream gauge data and modeling that they can perform on particularly the Medicine Bow, Sierra, Madres mountains to give us the results so you can feel comfortable that you're investing wisely in cloud seeding. I'd like you to drop your eyes down to column or row K. You recall the Goshen Irrigation District catastrophe that happened a couple of years ago. It was a real challenge and it's cost everyone a lot of money. Those farmers are paying the maximum amount of assessments. As a state, we continue to provide grants and loans to them to fix that problem. So you ask us, how many of these hidden surprises are out there? How many infrastructures in our irrigation system are really potentially time bombs? And so we've asked the Water Development Office to focus on a study, and you can glance across there, $500,000. We're going to do a statewide evaluation and determine how many time bombs are out there so we can quantify them and put our arms around them and perhaps either plan in advance or at least be better prepared for a catastrophe like happened in Goshen County. Those are the unusual things. Mr. Chairman, I'm going to close it down there. Everyone's read the bill. I'm going to open it up for questions in case anyone has a specific question.
Any discussion? Question being called. All those in favor of Chairman Eklund's motion that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 73 do pass, please say aye. Aye. Opposed, say no. House Bill 73 has passed the Committee of the Whole. The next bill for our consideration is House Bill 63. Reading clerk, please read the bill.
House Bill 63, sponsored by Representative Greer. County and District Attorneys' Salary Amendments, an act relating to the administration of government. Mr. Speaker, your committee number 2, Appropriations, to whom is referred House Bill 63, County and District Attorneys' Salary Amendments, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Kenner, Larson-Lloyd, Nicholas, Schwartz, Simpson, Stith, Walters. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move when the Committee of the Whole rise and report, it does so with the recommendation that House Bill 63 do pass. And I will turn the explanation of the Standing Committee amendment and the bill over to the good representative from Worland.
Chairman Greer.
Yeah, thank you, Mr. Chairman. So basically covered this when we did the introductory vote, but I'll refresh our recollection. Regarding district attorneys and our county attorneys, and this is, for me, more geared towards the county attorneys. Constitution requires that their salary be established by the legislature. It's been found that a range of salaries is appropriate. What's in the statute right now is a range of salaries between $35,000 a year to $100,000 per year. Okay. Now, on the county attorneys, the state pays the lesser of 50% of the salary, or $50,000. So the county commissioners are the ones for the county attorneys that set the salary, but there's this cap on it. Okay. Now with the DAs, and there's 2 DAs, one in this county because it's a single district, and one in Natrona County, single district. They're like their own agency, but their salaries are still set, still capped. Okay. But they go through a budgeting process with JAC for their overall offices because they're 100% funded by the state. So what I brought before you was a bill that raised the cap, so local control, so the county commissioners make this decision, that raised the cap up to the same level as the district court judge, which was $160,000. And remember I said I'd take this to JAC and discuss this with them. They bumped it back down to the circuit court level, which I believe is $140,000. $145,000, okay? And then they also, with respect to the DA, so the district attorneys in the 2 counties, and it is subject to basically legislative review or subject to the appropriation process, which is approved by this. So I look at this, the county I'm from, our county attorney isn't even at the $100,000 level. But there are quite a few counties around this state where you have, one, more duties, more deputies, more to do, and then higher costs of living, and the ability, and we're going to find this probably a little bit more in some of the smaller counties, is actually the ability to draw and bring in qualified attorneys. I've stood up here year after year after year and complained about prosecutors. Every time we bring a bill to make their job easier, I get up and defend the rights of the individuals. But one of the best ways we can defend the rights of the individuals is make sure we have quality prosecutors, for darn sure. So, Mr. Chairman, what I will do is move Standing Committee Amendment number 1, which is where the Reviewing Committee, the Appropriations Committee, lowered the amount from the circuit court level down to, from the district court level down to the circuit court level, and take any questions on that issue. And if there are none, dispense with that.
Any discussion on the Standing Committee amendment? Representative Oakley.
Thank you, Mr. Chair. I'm going to speak more fully, I suppose, on the whole issue in support of it, but I guess I would speak against the committee amendment that takes it down to circuit court judges. You're talking about a difference then of $15,000, so fairly negligible, but it still goes to the whole heart of the issue, which is that should be up to the county. That should be up to the county commissioners. If they want to pay that in the mountainous county to the west, then they should be allowed to do so. This isn't even asking for funding from the state. It's asking for local control to allow that. And in addition, something again that I was going to say about the entire bill, but the county attorneys specifically are doing, they're doing a lot of work, but specifically felony trials. With my boss, I've taken trials, murder, attempted murder, child abuse. We've gone to felony trials on that. And the association that works with the attorneys nationwide has a standard that says a felony trial attorney should be paid comparably to a felony court judge, which makes sense. Actually, it's the prosecutor that would have the beyond a reasonable doubt standard to prove. And of course, then the felony court judge, and they both need to have an equal knowledge of case law, evidentiary, court rules, all of that stuff. So they said, basically a standard is that those should be on par. So without this amendment, that's what it essentially was to have it on par with the district court judge. This switches it to a circuit court judge, which in Wyoming, so that's your misdemeanor judges, and that also do small claims. So significantly less, significantly less stress or, a standard, if you will. So it actually makes more sense on parity to have county attorneys at the level of district court judge. So on and against the amendment.
Representative Washut.
Thank you, Mr. Chairman. Just a quick question. If we start adjusting prosecutor salaries, will there be a reciprocal effect on public defender salaries? Where do they fall comparable to the prosecutor salaries, and will this cause them to come forward and ask the body for additional funding for them as well?
Chairman Greer.
Okay, let me first go back to if some of the folks or some of the members desire to leave the level at the higher level, what I would ask is that you bring that as a second reading amendment, but pass the standing committee amendment. And the reason I ask that is you recall during introduction, I inadvertently bumped the DA's salaries right to the top, and that's not what I wanted. And so that language is in the standing committee amendment to fix that. So if we want to have a discussion on whether 145 or 165 is the amount, I would just ask bring that as another amendment if this passes committee of the whole. Also, the thing I neglected to say is with respect to the county attorneys, we kept the maximum state contribution at $50,000. There's no more cost to the state. The counties, the county commissioners decide out of their own budget or their own pocket whether or not they're going to pay more for their county attorney. Now, with respect to the public defender's office, not since I've been on JAC 6 years ago do I know what their salaries are. As a general rule, they do get paid less. As a general rule, that agency is always saying they need more. Most agencies have a tendency to say that. But also remember, with the public defender's office, that's a constitutional duty that we owe. And so will they come forward if we do this raise and ask for more money? I don't know the answer to that. I would say, I would guess it's probably more likely than not. But again, remember, our court system, our rights to a public defender, our rights to be in front of a tribunal, in front of our peers and a jury, are some of our most basic fundamental rights of our Constitution, and they're very, very important. So hopefully I've answered those questions, and so I guess I would ask that we go ahead and vote on the standing committee amendment.
Question being called on Standing Committee Amendment number 1. All those in favor, please say aye.
Aye.
All those opposed, say no. Standing Committee Amendment number 1 has been adopted. We are back on the bill. Representative Oakley.
Thank you, Mr. Chair. I wanted to start out, and I didn't last time because I didn't realize I was going to speak about the amendment, but just to say that I have declared a conflict, even though I don't really technically have one. I'm not the elected county attorney, but nonetheless, I'm in a unique position, I guess, to discuss the issue. And I'm always surprised, and it's been explained well, but that this is difficult when this body, so often we seem to have a consensus about freedom, about local and county control, and yet by function, what this statute has done is arbitrarily and artificially kept a low ceiling for county attorneys across the state. And specifically, I think, since it's tied to district attorney, county attorney, the 21 of 23 of our counties, have county attorneys. And so I've already discussed that, so to broadly understand all of a county attorney's duties, of course, as I said, many are still, and they're responsible for, overseeing all the felony trials that are done in this state. That alone is a very big, very difficult undertaking. Takes a lot of stress, preparation, knowledge. But of course, for a county attorney, on top of that, they're an administrator. They have budgets. They have staff that they have to manage. And of course, on top of that, they are responsible for the legal advice given to all of the other county electeds. So that involves tax issues, elections, all sort of things. And some of these counties, it is an extremely big job. And all this asks is that you let those counties manage their business. Some of these counties, it's way too big of a job for what this is capped at, and it doesn't even cost the state a thing. All this does is allow those counties to manage their own, their own affairs and pay what's appropriate so that they can get good quality attorneys in there. I can speak specifically to a couple counties right now that I know that the county attorney has said they're just not going to continue on. They can just make significantly more, and the stress for what the pay is not worth it. So this is just basically, again, allowing counties to manage their own affairs, and I would urge an aye vote.
Any further discussion? Representative Knapp.
Thank you, Mr. Chairman. On and for the bill. The way that I look at this isn't so much as raises either. This is setting the market adjustment basically for county attorneys. We see it in every other aspect of every other job. And I think this just allows the counties to have that market cap raised so that they can make a decision of what they choose to pay. Thank you.
Chairman Zwanitzer.
Thank you, Mr. Speaker. Just perhaps present the other side of the argument. And it really is our Constitution. It's Article 15, Section 3, the legislature to designate county officers and fix the salaries of the county officers. And it reads, the legislature shall by law designate county offices and shall, from time to time, fix the salaries of county officers, which shall in all cases be in proportion to the value of the services rendered and the duties performed. And so this is where it always gets me, proportion to the value of the services rendered and the duties performed. I thought we had a really good bill about housing allowances, right? Because I understand that, you know, some of the county officers and the county attorneys in this case, they live in higher expense counties. And I thought the right way to go in line with the Constitution was certainly to say, hey, we could do a housing allowance like we do for teachers or state employees in some of these higher level counties. What bothers me is when we say the value of the services rendered are somehow different in one county than they are in another county. And I guess you could argue on the quality of whatever, county official and their competency. But the Constitution set out the pretty clear expectation that it was this body responsible for setting those salaries. We've given up and ceded a little bit of that authority over the past 20 years. Those of you who are here, I think it was in 08, 09, we had a fairly significant battle when we let the counties say, hey, there's kind of pay bands. And that's how you end up with, I think, 22 different county offices making more than 4 of our 5 state electeds. And so there's this balance thing we continue to struggle with. And now I think I actually appreciate we're trying to tie it to things, right? So district court judge, circuit court judge, what's county attorney make? I mean, that's pretty good. That's not maybe the same philosophy we have for executive branch employees with the MPP on what the market pays, right? We're not doing that. We're fixing salaries according to the Constitution, and we've ceded that authority to the counties, and we have some restrictions. But when I keep hearing I don't know why we don't do this, we don't do this because the Constitution, in my mind, is pretty clear that there's some sideboards that we're not always considering. And so again, I would say housing allowances, other things besides salary is really the way to go about this. I really enjoy what the Standing Committee Amendment did. I think it actually makes the bill a lot better. I'm going to support it now. I certainly was not before that. But I did want to present to the body, there's 20 years of history here on when we've now allowed counties to kind of have a lot more flexibility and ceded our legislative authority on fixing these salaries. That's the other side of the argument I think you should all be aware of.
Any further discussion? Anybody want to call for the question? Hey, question being called. All those in favor of Chairman Nicholas's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 63 do pass, please say aye. Those opposed, please say no. House Bill 63 has passed committee of the whole. Next bill for our consideration is House Bill 96. Reading clerk, please read the bill.
House Bill 96, sponsored by Representative Nicholas. State officials' salary, an act relating to state elected officials' salaries. Mr. Speaker, your committee number 2 appropriations, to whom is referred House Bill 96, state official salary, respectfully reports same back to the House with the recommendation that it do pass. Ayes, Representatives Kenner, Larson Lloyd, Nicholas, Schwartz, Simpson, Stith, Walters. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move when the committee of the whole rise and report it does so the recommendation that House Bill 96 do pass, and I will be happy to present the bill. So ladies and gentlemen, we talked about this obviously when we were introducing these bills. And just to refresh your memory, since we've done a few things since then, the last time that the 5 electeds received a pay increase was 2002. The current salary for the governor is $105,000, and the 4 electeds is $92,000. So, ladies and gentlemen, we just passed or did a first reading on county commissioners who now can make more than all of our 5 electeds if that passes. And I would suggest, respectfully suggest that that our 5 electeds are the only statewide elected officials. They are our representatives in state government. And I think it behooves us to treat them with respect and like at least other state officers in terms of salary. In addition to that, their duties are basically 24/7. Wherever they go, whatever they do, they're public figures and they're in the spotlight. And so their task is not easy, and they're always on demand. If you look at surrounding states, I talked about a little bit earlier, but Alaska, it's 145, Idaho 138, Montana 115, North Dakota 130, Oklahoma 147, Utah 150. What this does, it raises the governor to 140 and the Secretary of State and the other electeds to 125. If you take the value of what they were making in 2002 and added inflation, the equivalent is that means they're making about, in real money, from 2002, they're making about $60,000 a year for the four others, compared to what they were making in 2002, just with inflation. So we just get state employees raises. We've given them state employees raises multiple times since that time. But for some reason, we kind of just lag behind with our 5 electeds. And what's interesting is this bill has been up at least 3 times since I've been in the legislature. And we keep saying no, and we keep saying no. And so I would just request that now's the time to say yes.
Representative Fortner.
Thank you, Mr. Chairman. I oppose this bill for the simple reason I believe we'd be sending the wrong message to the private sector. There's people out there that's never bounced back yet, and we're talking about giving government a raise. That's insane. Vote no. Thank you.
Chairman Olson. Representative Gray.
Thank you, Mr. Chairman. I think he has an amendment, so thanks for letting me go first. I would definitely vote no on this bill. I have one question for the Chairman of Appropriations. He indicated on the introduction vote that they were going to have a vibrant discussion in appropriations on, I thought, adjusting the number, and I'm not seeing an amendment on that. So I think it was on this bill. Do you want that vibrant conversation to happen on second, third reading, or is there any interest in talking about the number on this? And did appropriations consider the number? Thank you.
Chairman Olson.
Thank you, Mr. Chairman. I would like to move Committee of the Whole Amendment Number 1 to House Bill 96, and I do ask for your favorable consideration. Folks, what this amendment does is it hinges on Senate File 106, and if Senate File 106 is enacted into law, then that's the triggering point for this amendment to take place. Senate File 106 creates the Wyoming Stable Token, which is a coin or token tethered to the US dollar. So it is equal to whatever the US dollar is at all times. Not getting too deep into this, but quick separation from currencies, virtual currencies that are volatile and go up and down every second. That's not what we're talking about. We're literally talking about a representation of the US dollar in the form of a virtual token. It will be tethered to the US dollar and will only go up with it or down with it. What SF 106 does is it creates a token and allows for the sale of the token to any person in Wyoming. When they purchase a token, what they do is they put $1 into Wyoming's treasury. That pool builds however many tokens are sold. Could be hundreds, thousands, millions, billions. The market range on tethered stable tokens in the world right now is in the billions. And so then a treasury pool builds. And SF 106 allows the treasurer's office to invest in treasury bills, T-bills, from that investment pool. Those are literally 99.9% risk-free investments. They have low return, but the goal is to have high return on those investments. So now that I've given you a little bit of background on the Wyoming Stable Token, which did pass out of committee resoundingly this morning, what this amendment does is allow for this increase in state elected official salaries to be paid out in Wyoming Stable Tokens. It is a may option, not a shall option. So if this bill is to be enacted into law, HB 96, and you are a statewide elected official, and you would like to take your increase, any portion of it, in Wyoming Stable Tokens, you may do so. If you don't want to do that, then you may receive it in US dollar. Completely optional. So just providing more, options for our electeds. I would guess I would liken this to a stock option, really, because the token is, at the end of the day, it's an investment opportunity for the state of Wyoming, which you'll hear a lot about when that bill comes over. So really what the statewide elected official is receiving, if they receive pay in the form of token, is stock in the state of Wyoming. I'll take any questions on this amendment.
Representative Western.
Thank you, Mr. Chairman. I rise in support of this amendment. Folks, I know this might kind of seem like a crazy idea, but when you really boil it down, it makes a lot of sense. Going on the analogy of the good chairman, it happens all the time in public companies where they get compensated in stocks and stock options in the company that they serve. Basically, it's the same thing, except this stock is Wyoming. It's the cowboy coin. It is issued by our state, backed by treasury bonds. And I think this is a great way that we can really kind of walk the plank on some of this stuff and really show that this works, has value. I think it would be a great way to reward our state elected. So please vote aye.
Representative Henderson.
Thank you, Mr. Chairman. Well, this is an interesting concept. As liaison to our Good State Retirement Board, we're still paying a lot of money for people who are using checks. And so I think this bill is a raise on five state employees or state officials. I think this is a great conversation in and of itself in many ways. But we've been pushing for a number of years to ask folks to help us cut costs of processing these payments, electronically. So I guess my question is there any transaction cost involved in this, similar to, for example, getting a check, converting it to the different type of exchange medium? And then, what if five people and it's on this increment? Why wouldn't, if someone wanted to use these tokens, they could go get them individually, I suppose, correct?
Question being called on committee of the whole. Oh, Chairman Nicholas.
So, ladies and gentlemen, I don't know if I want to walk the plank for this bill on a token. And I'm wondering what the bringer of this has been token. So, the on and against.
Chairman Olson.
I have to respond. This amendment actually is entirely friendly. I think it strengthens the bill. Again, it's a may option here. And so just trying to provide some more excitement behind this bill as it moves forward onto further readings. Thank you.
All those in favor of Committee of the Whole Amendment number 1, please say aye. All those opposed, please say no. Committee of the Whole Amendment number 1 has been adopted. Division being called. All those in favor, please rise. All those opposed, please rise. More than 14. That amendment has been defeated. Any other further discussion on House Bill 96? Representative Sweeney.
Very quickly, please vote aye on 96. One quick example, our current Secretary of State, who I think is doing a great job, applied for a judge. I haven't talked to him, his reasoning. I'm guessing the judgeship pays more, most likely less stress, a better thing for his family. This is why we need to increase these wages to be competitive so that the common man will feel comfortable in running for these positions. Please vote aye.
Question being called. All those in favor of Chairman Nicholas's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 96 do pass, please say aye. All those opposed, please say no. House Bill 96 has passed committee of the whole. Next bill for our consideration is House Bill 83. Reading clerk, please read the bill.
House Bill 83, sponsored by Representative Stith. Protection of Parental Rights Application, an act relating to parental rights. Mr. Speaker, your committee number 1, Judiciary, to whom is referred House Bill 83, Protection of Parental Rights Application, respectfully reports same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Craigo, Larson Dan, Oakley, Olson, Rodriguez Williams, Washit, Zwanitzer, Provenza. Noes, Representatives Provenza and Yen. Representative Olson, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Olson?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with the recommendation that House Bill 83 do pass, and I will turn the explanation of the bill over to the sponsor. Oh, there's a standing committee amendment, which I would also move, Mr. Chairman, which I will turn the explanation of the amendment also over to the sponsor of the bill.
Representative Stith.
Mr. Chairman, thank you. Members, House Bill 83, and I think we can make up some time on committee of the whole so that your bills that you have concerns about don't die on this one. What this bill does essentially in a nutshell is it makes sure that married parents have the same rights as single parents when it comes to custody decisions. That's the practical effect of this, because the existing laws interpreted by our highest court effectively means that single parents have different rights and more rights than married parents. And so anyone, if someone speaks against this, that's the question you should have in your mind is, why would we ever want to say that married parents have fewer rights than single parents? I don't think we do want to say that. I think we want the law to apply equally to them all. So what the bill does is it says that the parental rights statute passed in 2017 applies not just here in Title 14, where children are talked about and single parents' rights are adjudicated, but also in Title 20, where married parents' rights with respect to their children may also be adjudicated. With respect to the standing committee amendment, it essentially makes some technical corrections. Frankly, we added the word or replace the word or between child custody and visitation on the top of page 2, line 1. So now with the amendment, it would read child custody or visitation. That's just so that it grammatically flows, so that it applies to any one of those things: termination, neglect, visitation, custody, or. So that's, and then what the standing committee amendment also does is it makes the intent of the bill clear that our target here is to say that the courts have to comply with this. That is, the target of the bill is not the state agencies. The state agencies are already subject to the parental rights statute by the plain language of the existing law, because the existing law says that state agencies in taking action that would infringe the liberty interest of a parent in the care, custody, and control of their child must do so only with a state compelling interest and do so by the least restrictive means. So it's already applicable to state agencies. This makes it clear it applies to courts and that it applies to in divorce actions as well. And with that, I guess we may have a vote on the standing committee amendment, making the technical changes.
Any discussion on standing committee amendment? Question being called. All those in favor of standing committee amendment number 1, please say aye. All those opposed, please say no. Standing committee amendment number 1 has been adopted. We are back on the bill.
And Mr. Chairman, I believe there's a committee of the whole amendment.
Chairman Zwanitzer.
Thank you, Mr. Chairman. I move committee of the whole amendment number 1 to House Bill 83. And I think you all know I'm not an attorney, and so I'm a little bit out of my realm here. But I'm one of those people that can't understand why we would say in Title 14, which is our juvenile statutes, that this all applies to Title 20 without just putting it right there in Title 20. So Title 20 is our domestic relations statutes, which actually cover child custody, child visitation, married parents. And so what I'm doing is reflecting the language in Title 14. So it's also in Title 20. Not that I don't believe attorneys can look through all of our statutes, but it's probably easier just to put it in Title 20 so it's there, so we don't have another slip up saying, oh, I never read Title 14 and that it applies to Title 20. We just stick it right there in Title 20. Appreciate your support.
Representative Jennings.
Thank you, Mr. Chairman. So, members, the bill was brought because of a cause of action that the Supreme Court or the Justice's judicial system made a decision on. And I don't disagree with the bringer of this amendment. I have some concerns that if we start spelling out where this might apply, that we have to go back and apply it everywhere across the board. And I think the original statute, along with this clarification for the first one, or the bill, probably clarifies that well enough. So I guess I would be opposed to this amendment, not in that it does anything nefarious, but that it could lead to a narrower scope instead of the broader scope that we really wanted to approach. So thank you, Mr. Chairman.
Representative Stith.
Mr. Chairman, on the committee of the whole amendment, you can vote aye, you can vote no. You can think of the amendment as there for lawyers who don't know how to read. Okay, so if the lawyer is illiterate, then you need the amendment. So vote your conscience on that one.
Any further discussion on Committee of the Whole Amendment number 1? Chairman Zwanitzer?
I would never call a lawyer illiterate, and vote aye.
All those in favor of Committee of the Whole Amendment number 1, please say aye. All those opposed, please say no. Committee of the Whole Amendment number 1 has been adopted. We are back on the bill. Representative Stith.
Mr. Chairman, I don't want to take too much time at the microphone, but just briefly, I think this works. And a fun fact, when the courts do interpret the law, they are obligated to presume that the legislature acts with full knowledge of existing law. So think about that. You are presumed to have full knowledge of existing law at this very moment. Please vote aye.
Representative Yin.
Mr. Chairman, thank you. So when this came in committee, one of the things that I asked Representative Stith, and hopefully he can answer it this time as well, is what difference would this bill make? You know, he presented a court case for us where the Supreme Court said, because it's not specifically in the statute, we're going to ignore it. But I think the indication was that even if we had it in the statute, that they would still end up with the same outcome, which is that they would argue it's in the best interest of the child, and that even if this is in the statute, the outcome still wouldn't matter. So I guess I still need a situation where putting this in statute would actually make a difference, or are we just adding to the green books? Thank you, Mr. Chairman.
Representative Provenza.
Thank you, Mr. Chairman. I guess, you know, I would maybe feel differently about this if I thought that it came to us from a problem, that the justice system failed. But we heard in committee that this is based on a case that involved a father who refused to take anger management, who killed 3 family pets in front of his children. And the court took into consideration 10 different points about whether that father should have custody or not. And so what we heard in committee was this confuses the language. We've heard that we don't know why it's coming. And it sounds like we fixed the other point of the Title 20 and Title 14 issue in the amendment, but there's just a lot of questions for me still, and I think it's something worth considering more, given that the base case of this is something that worked. The Supreme Court protected the child, or protected the children. So I would urge a no vote and maybe welcome more discussion in an interim. But I really don't think that this body should be trying to impose itself on the discretion of our judiciary branch, particularly when it works. So vote no.
Representative Sweeney.
Thank you, Mr. Chairman. And I'll preface my remarks that I am not an attorney either, but House Bill 83, the parental rights are constitutionally protected and a vital element considered in family law cases. Unfortunately, House Bill 83 may confuse custody and divorce cases because it is not clear what the change means or how it is to be applied. A number of attorneys have recently contacted me and have concerns with the bill, primarily due to the confusion about what the bill really does, which you just kind of heard. Confusion over the application of the statute likely will mean a lack of consistency in how judges apply the change, which may lead to the Wyoming Supreme Court having to interpret and decide what this legislation means, which will not be helpful to parents. There seems to be confusion regarding how the current law treats married and single parents. But I won't go further, but I would ask for a no vote after looking at this a little more. And perhaps it needs to be studied by judiciary. I don't know the answer, but the people I'm talking to on this I would urge a no vote.
Representative Stith.
Mr. Chairman, appreciate the comments from the other representatives here. With respect to the question from the representative from District 16, it is a sort of theoretically interesting question of why do you need this at all? And the short answer is that the courts in making custody determinations often talk about the best interest of the child when they're talking about restricting parents' liberty interests, but they don't do the second step, which is to talk about the least restrictive means. So with that, I'd call for the question.
Question being called. All those in favor of Chairman Olson's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 83 do pass, please say aye. All those opposed, please say no. Pursuant to Rule 6-6B, having failed a voice vote, a standing vote is required. All those in favor, please stand. All those opposed, please stand. Less than 32. House Bill 83 has passed Committee of the Whole. We have a quick privilege of the floor. Representative Western.
Mr. Chairman, privilege of the floor.
Please go ahead.
Thank you, Mr. Chairman. So if we look in our South Gallery, we got some folks here from some of my towns, both in Dayton and Ranchester. If we could just stand and give them a warm house welcome. They're leaders, they're awesome folks, and they're also my constituents, and I need their votes. So let's give them a warm house welcome.
Welcome to the House, and thank you for joining us. Next bill for our consideration is House Bill 55. The reading clerk will read the bill.
House Bill 55, sponsored by Representative Walters. Liquor licenses, airport exemption, an act relating to alcoholic beverages. Mr. Speaker, your committee number 7, corporations, elections, and political subdivisions, to whom is referred House Bill 55. Liquor licenses, airport exemption. Respectful report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Blackburn, Burt, Clausen, Duncan, LeBeau, McGuire, Roscoe, Swanitzer. Noes, Representative Ayer, Representative Zwanitzer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Zwanitzer?
Thank you, Mr. Chairman. I move when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 55 do pass. There is one standing committee amendment I would move at this time. Before I turn it over, the standing committee amendment of this bill talks about airports and liquor. And when we talk about airports, we wanted to make sure everyone knew we were talking about commercial air service. And so you'll see we inserted commercial service before airports so that every person who has a field that wants to put up a sign that says airport cannot have a bar. There should be no discussion on that, although it would be interesting. And I would ask for your favorable aye vote on the standing committee amendment.
Question being called on Standing Committee Amendment number 1. All those in favor, please say aye. All those opposed, please say no. Standing Committee Amendment number 1 has been adopted. We are back on the bill. Representative Walters.
Thank you, Mr. Chairman. Before you members is House Bill 55, and what this does is it allows for an airport to be exempt from the number of licenses that are issued within a county. So there's a population for a municipality, population-based allotment for municipalities as to how many liquor licenses are available in a municipality. And then as you go out from the municipality, there's a 5-mile veil around that municipality that limits the number of liquor licenses to 3. And then if you go beyond that in the county, then it goes back to a somewhat of a population base for the county. And so what's occurring in many of our counties that have a commercial service airport, just as the good chairman discussed in the amendment, that it's now talking about commercial service airports in the county, is you have places that offer a beverage before a flight. However, there may only be 1 flight a day, so this place is open for 1 hour, 2 hours at max. And so it is taking a license out of the county's pool of licenses and using it for maybe 1 hour a day. So this would allow that county to be able to issue that license to an entrepreneur that would operate their establishment all day and not take it out of the pool of available licenses for this small use at these commercial service airports. Little sideline, there are 9 commercial service airports in the state of Wyoming, if someone was wondering. And again, it really is helping entrepreneurs in my mind, because it allows for that license to be in the pool to go out to somebody to operate it on a full-time basis.
Representative Washut.
Thank you, Mr. Chairman. Just a quick question. I think we've all seen the news stories recently about an increasing number of unruly and disruptive passengers on commercial aircraft. And I'm just wondering if the committee considered the service of alcohol in between flights, whether that might exacerbate an increasingly common occurrence of disruptive passengers.
Representative Walters.
Thank you, Mr. Chairman. The committee did not take up any consideration about the unruliness of passengers based on their consumption of these kind of beverages. I think the unruliness is just generally a cause of society as you look. It's not just on airlines, but it's in cities, downtowns, and throughout our society. Unruliness seems to be more standard and more commonplace than it used to be. So I don't believe that that would be an increase in this case. Many of these places already have these. It's really at the detriment of the county that these licenses are issued. And so this is more about helping the entrepreneur within the county to be able to open something for more than just an hour or 2 a day.
We do have a Committee of the Whole amendment. Representative Stith.
Mr. Chairman, members, I move Committee of the Whole Amendment number 1 to House Bill 55 and ask for your favorable consideration. So this bill is about allowing airports to have a liquor license that are in the county. So if it's a good idea, which I think it is, then it would also make sense to have airports that happen to be located inside of city limits have the same privilege. So that's what this committee amendment does. I believe there are 2 airports in the state that have airports inside of city limits. And so I think this would be a good thing, and ask for your favorable consideration.
Representative Walters.
Thank you, Mr. Chairman. I consider this to be a very friendly amendment, and actually the community where the good bringer resides from. If you've ever been to their airport, you'd be shocked to say that it's in the city limits. However, it was annexed into the city many, many years ago before it had to have a an annexation had to be tied directly to the municipality. And so I thought I had covered all of this in the bill, and then discovered that at least in that fair city, that their airport is actually in the city while being many miles outside of the city. So I think this is a great amendment, and I appreciate the bringer. Please vote aye on the amendment.
Chairman Zwanitzer.
While I personally will vote yes and very much like the amendment, I do want to be fair that this is a full retail liquor license. And so if you have an airport inside a municipality, and this is a packaged liquor store as well and a full bar. And so I know it's only 2 communities, but you might get to a point in one of them where they have more people attending that facility for a bar or to buy packaged liquor than they do for air service, which slightly concerns me. One thing that wasn't mentioned is a lot of the times part of this packaged liquor thing is to take alcohol on flights. We have some Wyoming products that are distilled here that are famous that we can sell in airports. And so some of this causation for the bill was really so you could take those products, buy them in the airport as souvenirs or gifts, and take them back with you and have that retail liquor license allow that. With the addition of this amendment, I would say those 2 cities will get a significant bonus to getting one more liquor license in their community, which in my case, I think sounds kind of good, but I just wanted the body to make sure you were aware of the ramifications.
Representative Banks.
Your Honor, thank you. Just to sort of reiterate, did I say Your Honor? I just promoted you.
I like the promotion. Thank you, Representative Banks. You're good.
Just to sort of reiterate what the great representative from the center of the state said, if you've been to my community, which is one of the communities in question, you know that no one is going to drive to the airport to buy liquor. It is a 15-minute drive, perhaps. It's really not, and it's also not going to add a liquor license in that it doesn't take anything out of our community. It's not adding a new liquor license into our community in any way. It is just allowing our airport, which I don't even know, frankly, if they would take advantage of it, because at the moment there is no caterer there. They serve food is done by a vending machine. So I don't know that this really truly has a huge benefit, but the unamended, it does leave out 2 airports in the state. So thank you.
Question on the amendment. All those in favor of Committee of the Whole Amendment number 1, please say aye. All those opposed, please say no. Committee of the Whole Amendment number 1 has been adopted. We are back on the bill. Any further discussion on the bill? Question being called. All those in favor of Chairman Zwanitzer's motion that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 55 do pass, please say aye. Those opposed, please say no. House Bill 55 is passed the Committee of the Whole. The next bill for our consideration is House Bill 117. The reading clerk will read the bill.
House Bill 117, sponsored by Representative Kenner. Occupational Therapy Licensure Compact, an act relating to professions and occupations. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred House Bill 117, Occupational Therapy Licensure Compact. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Connolly, Flitner, Hallinan, LeBeau, Ottman, Wilson. Noes, Representatives Stivar, Morf. Excused, Representative Romero Martinez. Representative Wilson, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Wilson?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, to do so with the recommendation that House Bill 117 do pass. Before I turn it over to the sponsor of the bill, I would also move the Standing Committee Amendment, which is just one of those legislative service office cleanups where they discover some statute references that were left out. There's a number of them, and there was also a mislabeling of Section 2, which ought to say Section 3. So I would call for an aye vote on that.
Seeing no discussion, all those in favor of Standing Committee Amendment number 1, please say aye.
Aye.
All those opposed, please say no. Standing Committee Amendment number 1 has been adopted. We are back on the bill. Chairman Wilson.
Thank you, Mr. Chairman. And so then I would turn over the explanation of the bill to our good member from House District 29.
Representative Kenner.
Thank you, Mr. Chairman.
Members of the 66th, Mr. Chairman, I do have a committee of the whole amendment. I'd like to take care of that right away if I could. So ladies and gentlemen, after the other amendment was prepared and after we went to the committee, there were some further conforming amendments to match the compact language. And so I would move that we approve the committee of the whole amendment number 1.
Question being called on Committee of the Whole Amendment Number 1. All those in favor, please say aye. All those opposed, no. Committee of the Whole Amendment Number 1 has been adopted. Back on the bill, Representative Kenner.
Thank you, Mr. Chairman. Ladies and gentlemen, if you remember from last week when we did the introducand the problem that I was trying to solve was to provide occupational therapists for healthcare in Wyoming and help that recruiting healthcare professionals. And so really improving access to occupational therapy, increasing market opportunities for OTs. And here's a new one, telehealth would be something that we could do, and then support relocating military spouses. So with that, I don't want you to be intimidated by the thickness of this bill. This is a compact bill, and not compact in that it has a few pages, but it does have a lot, but it is a occupational therapy compact. So let me tell you what that does. We would enter into a compact with other states. This would allow occupational therapists and occupational therapy assistants in one compact state to also have the same privilege in other compact states. We would authorize rulemaking. We would retain, this is really important, we would retain our own authority to license occupational therapists within Wyoming. And let's see, and we would also approve the terms of the compact and then make conforming amendments. Now, in this, I'm not going to walk through the whole bill with you unless you have some specific questions, but it does have all those things that you might imagine it would have. It does have the definitions. It talks about the compact itself. It talks about if concerns arise, and ladies and gentlemen in the committee, one of the questions was, could we ever get out of a compact if we want to? And the answer to that is yes, we can get out of it. It does take about 6 months to get out of it, in fact, but there is a provision for that in the compact. And so we do have that. Now, the question also came up in our committee work that how many states have actually resigned from a compact? And the answer was only one out of all the compacts and out of all the years has a state resigned from a compact. And so that was good to note. Some other questions that came up in the committee: how many occupational therapists do we have in Wyoming? We have 433, and we have 159 occupational therapy assistants. Now, what other compacts are we familiar with that we already have in Wyoming? So let me just share those with you. We have nurse licensure, we have advanced practice registered nurse, we have physical therapy, we have emergency medical services, we have some in the area of psychology, interjurisdictional compact. We do have some also in medicine, compact counseling, audiology, and speech, language, and hearing. So my point is that we are familiar with compacts. Now, this came to me from a constituent and said, I was trying to recruit right here in the capital city, and I had an applicant that was a possibility south of the border, but it was going to take them a considerable amount of time to go through the licensure. If they were a member of the compact, guess what? They could have gone through the registration process and proven that they were a compact member and gone ahead and transferred their license to our state. And so now on the telehealth, I want to mention this, that one of the things that's exciting for me to think about is just recently in Sheridan, in the town where I reside at the base of the Bighorns, we had a snowstorm. There was a young person that was supposed to come to Sheridan for the base of the Bighorns for therapy, and they weren't able to do that because of the roads. Had we had a compact in place, they reside over the border to the state north of us. they could have gone online and received the therapy online, because if they were a compact member, we could have done that across state boundaries without too much problem. So I really like that as one of the other advantages of doing this. We do have the support of the organization that is the association. We do have the support from other medical related groups. We do, by the way, have an occupational therapy program in Wyoming. It's in the city in the center of the state. It's a community college. And then you can also get a master's or a doctorate through a state to the further the north. And I'm thinking that I've provided enough information, hopefully, for you to support House Bill 117.
Question being called. All those in favor of Chairman Wilson's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 117 do pass, please say aye. All those opposed, please say no. House Bill 117 has passed committee of the whole. Representative Stith, privilege of the floor.
Privilege of the floor, Mr. Chairman.
Go ahead.
Mr. Chairman, I'd like the body to recognize we have today the Executive Director of the Sweetwater County Airport, as well as and who also serves as the Director of our Sweetwater Economic Development Coalition, Devin Brubaker, here in the South Gallery.
Welcome to the House. Thanks for joining us. The next bill for our consideration is House Bill 125. The reading clerk will read the bill.
House Bill 125, sponsored by Representative Connolly. Workplace Injury Assistance, Information and Guidance, an act relating to labor and employment. Mr. Speaker, your Committee Number 9, Minerals, Business and Economic Development, to whom is referred House Bill 125, Workplace Injury Assistance, Information and Guidance, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Baer, Burkhart, Duncan, Ayer, Gray, Greer, Heiner, Sherwood, Western. Representative Greer, Chairman.
You have heard the reading of the bill. What is your pleasure, Vice Chairman Duncan?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with the recommendation that Bill number 125 do pass, and I further move the adoption of the Standing Committee Amendment number 1, and I'm going to turn it over to the Minority Floor Leader to explain both.
Minority Floor Leader Connolly.
Thank you, Mr. Chairman. First, friends, I'd like to take care of the Standing Committee Amendment. The Standing Committee Amendment simply exchanges the reporting requirement at the end of the bill from a standalone report to one that the Department of Workforce Services is already providing and including this new information. And with that, I just ask for your favorable consideration on the Standing Committee Amendment.
Question being called on the Standing Committee Amendment. All those in favor, please say aye. All those opposed, no. Standing Committee Amendment number 1 has been adopted. Back on the bill,
Okay.
Minority Floor Leader Connolly.
Thank you, Mr. Chairman. Friends, if you remember, what this bill does is it expands the duties of the Department of Workforce Services Director and agency to allow them to provide information and guidance not only to those employers and employees covered under workers' comp, but also to those who are self-insured when there's a workplace accident. So the background on this bill is that it goes all the way back to the first special session regarding COVID, where we needed to address the impact of the pandemic on employers and employees in relation to illness in the workforce and perhaps business closures. So if you remember, we modified our statutes to establish a presumption of COVID transmission at a workplace so that an employee would be eligible for workers' comp rather than unemployment, and the employer's unemployment rating would remain stable. That was good. We did good with that. But in the midst of that, we recognize that a significant portion of our population is not covered by workers' comp. As a state, we only require workers' comp for hazardous workplaces, plus we allow other employers to opt in, which many, many do. Remember that workers' comp is a grand bargain that employers and employees agree to. No one wants a workplace injury. We have rules and regulations, safety, et cetera, right, that we are happy with, but workplace accidents do happen. And when they do happen, an injured worker taps into the workers' comp system and their medical expenses are taken care of, right? There's no ability to sue by the employee. The workers' comp system has been paid for by employers. Again, it's one of those what we call a grand bargain in labor law. But remember that not all employers in Wyoming choose to be part of our workers' comp system. Instead, are what's called self-insured. They carry their own insurance for workplace accidents. So 2 years ago, when we added that presumption regarding COVID to workers' comp, all of those self-insured employers and employees were not and could not be included. And they had to rely on unemployment. And they also had to rely on wherever for necessary information about what to do. Remember, when we think about workplace accidents, we honestly think about, boxes falling on your head, a slip and fall, things like that, right? Where the cause and effect is right there, right? Causation with COVID is much more complicated. So one of the things, honestly, that the good chair of labor health and I did over the interim is think about that. Honestly, we recognize that we didn't take care of those employers and employees 2 years ago. So we thought about it and what was possible for us to do. So we looked at what other states did, for example, and honestly, many of them require all employers to be part of the statewide workers' comp system. Others have parallel systems within the equivalent of our Department of Workforce Services, but honestly, self-insured employers pay into that a bit of an administrative fee. Ultimately, we decided we did not want to go down that route. And instead, what we have here in front of you is honestly a simple bill. A first step that goes into Title IX, not the workers' comp title, which is Title 27, because remember, that one there is completely and wholly kind of administered by funds that covered employers are paying into. But instead, we go into Title IX, the duties of the director of the department, and we have her, and then this is the meat of the bill. And you can see it on page 2. Have the director of the Department of Workforce Services provide information to all employers and employees regarding the kind of opportunities that are available to them regarding what to do when there is a workplace injury. And that's the meat of the bill. You have 4 elements there that the director and/or their designee will take care of. And I want to tell you that we had a nice conversation in the committee meeting about it. And without solicitation, both members of the business community as well as organized labor came and testified in favor of the bill, that this information was necessary, as well as the department itself, which honestly wasn't thrilled with one of the elements here about the element D or element E, right? Providing information about available insurance and what it would look like, and actually saw in the room that there was an insurance commissioner and went over and had a conversation and said, oh my goodness, I didn't even know that that information existed and we really should have. So honestly, this is a bill that we can already see that there is the desire, not only the desire, but the need for kind of getting that information from agency to agency and then out to both employers and employees. And with that, I'd ask for your favorable consideration.
Chairman Wilson.
Thank you, Mr. Chairman. I want to thank the bringer of the bill for bringing this, and you'll see that my name is on it. And I would encourage you all to vote for it. It sounds a little, why are we getting reports and why can't they do reports anyway already? I mean, that would be sort of a first answer. But to be honest, when these situations came to my attention through constituents and so on, starting several years ago, it's one of those areas where you suddenly realize that there's a whole universe out there of employees who are not covered under our workers' comp laws. And we wanted to be able to get more information, understand what happens to those folks, what's the size of the problem, not to provide them legal advice. I was just inquired about that. We will not be authorizing them to provide legal advice. We will leave that out there for any lawyer here who feels the need of more work. But we do need more information so that we can do our proper work, monitoring or just keeping track of of what goes on in the workforce and their needs. And so I would ask you to vote aye.
Question being called. All those in favor of Vice Chairman Duncan's motion that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 125 do pass, please say aye. All those opposed, please say no. House Bill 125 is passed Committee of the Whole. We are on to our next bill, House Bill 62. The reading clerk will please read the bill.
House Bill 62, sponsored by corporations. Insurance amendments, an act relating to insurance. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred House Bill 62, Insurance Amendments, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Blackburn, Burt, Clausen, Duncan, Air, LeBeau, McGuire, Roscoe, Swanitzer. Representative Swanitzer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Swanitzer?
Thank you, Mr. Chairman. I move when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 62 do pass. I would further move the Standing Committee Amendment number 1, and not finding anyone on my committee who wanted to talk about insurance, I'll be presenting the bill. Two major things going on with House Bill 62, and they are kind of major. The first one is just an update to definitions. And so let me just walk you through the major updates we're doing, which is a roughly $7 million swing to our budget. So first, we're updating the definition of adjuster. And so this was an ongoing conversation for 6 months between our industry partners and the Department of Insurance, trying to make sure we got it right. And to be honest, committee, we didn't quite get it right in the interim, which is why you see Standing Committee Amendment number 1 before you. With an aye vote on that, you go from the fiscal note of this bill being $6 million deficit to about a $730,000 benefit to our department in our state. So that's how much this language truly matters. Other definitions we updated were just appraiser and the word umpire as it pertains to property and casualty claim procedures. And you can see that in the bill and also in the amendment. Just some small tweaking on about 4 words makes a huge difference. We also went through our statutes and we did not have a definition for what a public adjuster is, which was kind of weird since it's multiple places in our statutes. We use it in our regulations, but we'd never actually defined what a public adjuster is. So we actually went to the model industry language. I can't say the name, but it's the commission that all of our insurance commissioners belong to and meet regularly with on kind of model language that's the industry standard. So that's the first part of the bill that actually deals with the Standing Committee Amendment, which I'll ask you to vote aye on. We updated after a long conversation, again, with our industry partners and our department. And the way we're going to phrase it now, we'll take away that horribly looking bad fiscal note and make this a revenue generator for the state. I'd be happy to answer any questions on the Standing Committee Amendment number 1.
Question being called. All those in favor of Standing Committee Amendment number 1, please say aye. All those opposed, please say no. Standing Committee Amendment number 1 has been adopted. Chairman, would you like to move Committee of the Whole Amendment?
I would, Mr. Chairman. I'm going to move Committee of the Whole Amendment number 1 at this time. And because that Standing Committee Amendment passed, we went back and looked. If you look through the bill, there's actually multiple effective dates. And in changing some of the definitions in the Standing Committee Amendment, we then realized our effective dates were off. The quick version is some of these things need to be effective immediately. Some need to be held back a year. You have to do notification. We have to do updates with vendors. And so we don't want certain things taking place immediately because sometimes our insurance industry partners, they don't like surprises on short notice and they need some time to get used to things. And so we're not making that part effective immediately. That is what the Committee of the Whole Amendment number 1 does. Be happy to answer any questions. Otherwise, would call for the question on Committee of the Whole Amendment number 1.
Seeing no discussion, question being called on Committee of the Whole Amendment number 1. All those in favor, please say aye. All those opposed, please say no. Committee of the Whole Amendment number 1 has been adopted. We are back on the bill, Chairman.
Thank you, Mr. Chairman. And the rest of the bill, the second part of what we're doing is really moving the burden of continuing education fees from our insurance providers to basically the industry of continuing education for insurers that exists. And so we're one of the last states that continue to burden our providers with having to pay for the cost of doing this continuing education. We are now going to make the people who provide the continuing education have larger fees, as you can see there on pages 4 and 5. And so it'll Resident license fees will now go to $100 if you're a resident. If you're a non-resident, you're going to pay $150 for that continuing education. With many things we do in our statutes, we felt that was much more fair to give in-state providers a cheaper license in this regard. If you're an out-of-state operator who's coming into Wyoming, you should probably pay a little more. Happy to answer questions on that. Otherwise, would call for the question on House Bill 62, insurance amendments.
Seeing nobody rushing to the mic and question being called, all those in favor of Chairman Zwanitzer's motion that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 62 do pass, please say aye. All those opposed, please say no. House Bill 62 has passed the Committee of the Whole. The next bill for our consideration is House Bill 31. Reading clerk, please read the bill.
House Bill 31, sponsored by Education. Wyoming's Tomorrow Scholarship Program, an act relating to higher education. Mr. Speaker, your Committee Number 4 Education, to whom is referred House Bill 31, Wyoming's Tomorrow Scholarship Program, respectfully reports same back to the House with the recommendation that it do pass. Ayes, Representatives Andrew, Brown, Connolly, Harshman, Nyman, Newsom, Obermueller, Paxton, Summers. Representative Paxton, Chairman.
You've heard the reading of the bill. Chairman Paxton, what is your pleasure?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 31 do pass. I also move the Standing Committee amendment and turn the explanation of the amendment over to the good Chairman of Appropriations.
Chairman Harshman. Oh, Chairman of Appropriations.
Yep.
Chairman Nicholas.
Thank you, Mr. Chairman. Ladies and gentlemen, on re-referral, this came to the Appropriations, and the Appropriations Committee, there was $1,000 kind of an initial deposit into this account. In order, and at the request of the bringer of the bill, so that there isn't an appropriation on this, just to make sure that it doesn't get bogged down in just $1,000, we removed the $1,000, so we just create the account.
Any discussion? Seeing none. All those in favor of Standing Committee Amendment Number 1, please say aye. Aye. All those opposed, no. Standing Committee Amendment Number 1 is adopted. Chairman Harshman.
Thank you, Mr. Chairman. Members, House Bill 31 is, I'll just be real brief. There's a lot of bills on Committee of the Whole, and I'll stand here for any questions, but basically it's an adult scholarship program that we've been working on the last 3 years, patterned after several states. Most states have initiatives like this, widely supported by every industry in our state. And we're going to try to fund this much like we've done with other important programs in our state with an endowment. And so we'll continue down that road. But basically, folks who are 24 years of age or older in our state, citizens of our state, I can go through all the criteria if you'd like. I'd be happy to walk through the bill page by page. I thought I'd give you the brief explanation, but basically a 24-year-old who is working in the state, who's already here and wants to go back and kind of re-credential or improve their training. This whole workforce development is a huge deal. And Wyoming, of course, our demographics are tough. And we've got a growing problem with the shrinking solution. And so this is one of these things. We've worked with the Attainment Council, industry, and many stakeholders across the state. We've met for, I think, 28 days. We intended for this to be a joint education bill last year. This bill passed out of this House, was stalled in the other end in committee, really over funding issues. Was intended to be an education committee bill last year. You remember the good chairman passed away, and so it was brought back this year, worked on the entire interim by our joint education committee. So I'd stand here for any questions or call for the question if there's any question.
Seeing nobody rushing to the mic and question being called, all those in favor of Chairman Paxton's motion that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 31 do pass, please say aye. Aye. All those opposed, please say no. House Bill 31 has passed Committee of the Whole. The next bill for our consideration is House Bill 56. The reading clerk will read the bill.
House Bill 56, sponsored by Management Audit. Examination of books of certain districts and entities. An act relating to the Department of Audit, examination of books of special districts and certain specified entities. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred House Bill 56. Examination of books of certain districts and entities. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes. Representatives Blackburn, Burt, Duncan, Air, LeBeau, McGuire, Roscoe, Swanitzer. Excused, Representative Clausen. Representative Swanitzer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Swanitzer?
Thank you, Mr. Chairman. I move in the Committee of the Whole rise to report it do so with a recommendation that House Bill 56 do pass. There is a standing committee amendment we put on in committee, so I'd further move that at this time. And the standing committee amendment, as far as I know, is just some cleanup language. And we had a small discussion that the language, this is 56. Let me just move the standing committee amendment at this time and ask for your favorable consideration before I turn it over to the good speaker. But I'd be happy to answer any questions on the standing committee amendment. Otherwise, it was just a cleanup that was asked for by the municipalities.
Seeing no discussion, all those in favor of Standing Committee Amendment number 1, please say aye. All those opposed, please say no. Standing Committee Amendment number 1 has been adopted. We're back on the bill and to Speaker Barlow.
Thank you, Mr. Chairman. So members, this is a bill, one of a series of bills that came through a Management Audit Committee. This particular one has to do with challenges that we sometimes have with special districts and other entities that do not report their books, if you will, their audits, findings, or simpler type findings, balance sheets to the Department of Audit, which then the Department of Audit uses to ensure that funds that come from other governmental agencies, including the state, are used properly. They are the source of how we get our cost of government reports, these audits. So over the last couple of years, your Management Audit Committee has been trying to make sure that the folks are actually responding to these, and a lot of times it ends up, there's some non-compliance, and it ends up being folks that are, they're not, the special district is not even functional anymore. It's not even in existence. So, but we have found some that are just don't think think they need to be responsive to this audit requirement. So that's what this bill is going after. It's basically affirming that, and you'll see there's a lot of language that basically inserts some new language, 1612 202A. These are a list of special districts that are in statute that are either formed, they're either elected, or they're either put in by the voters, or they're formed by county commissions, such as library districts and et cetera, museum districts, that do have a responsibility to report, but some of them have said, we're just not so sure we should. So this is just clarifying that those entities are responsible for the, as on page 2 of the bill, for the reporting of the books and accounts. And what you see is that language carried through the entirety of the bill. Now, in the standing committee amendment, I think there was maybe a misunderstanding. I'm going to have to look at the standing committee amendment a little closer, because I think one of the parts was I'm going to come back with a third reading amendment and clean it up. But I want to go to lines, page 5, 16, and 17, just to clarify something, because you may have heard about this from your communities. So this is about failing to supply the Department of Audit the appropriate reports. Well, if you look at lines 16 and 17, we give some pretty broad dissolution powers to the county commissioners. And there's some concern about how those are. This is literally over an audit requirement. Then we're saying you have some obligation to dissolve these special boards. And there was some testimony in committee, obviously, that, hey, let's hold back on that. There's already ways to dissolve these boards and things. So we don't need to add another layer of complexity to this. So that's what that standing committee amendment did. The rest of the language, like I said, there's some cleanup language, and there's one component that I may come back with a second reading or third reading amendment on. But literally, ladies and gentlemen, this is about making sure that the reports we're getting are timely, accurate, and that we can understand what those special districts and other entities in our communities are spending of government funds. Thank you, Mr. Chairman.
Representative Larson.
Mr. Chairman, thank you. I just have a small question. I agree the need to report. I just wanted to ask, are there forms out there that make it simple? Or is it just a matter of sending in a balance sheet and also showing expenses and revenues?
Speaker Barlow.
Thank you, Mr. Chairman. So with that department that's responsible for this, they have an entire a workbook with all the forms online. Everything is needed. There's, as you know, different levels of assets and revenues have different levels of reports that are due. So if you're a very small district with a couple thousand or $20,000, it may just be your balance sheet, your check register, and certainly if you're over $1 million, then it's a full-blown audit. So there are different levels of complexity, but that's all available directly from the audit, and they actually are, I think, quite. They want folks to be in compliance, so they go out of their way to assist folks in accomplishing this task, this obligation. Excuse me. It's not just a task; it's an obligation. Thank you.
Seeing no discussion and looking for a question to be called. There we go. Question being called. All those in favor of Chairman Swanitzer's motion that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 56 do pass, please say aye. Those opposed, please say no. House Bill 56 has passed Committee of the Whole. Majority Floor Leader Summers.
Mr. Chairman, thank you. So the next 10 in Committee of the Whole are the following: 60, 10, 18, 5, 146, 131, 81, 110, 107, and 76.
I'll go ahead and repeat that just so members have that. House Bill 60, 10, 18, 5, 146, 131, 81, 110, 107, and 76. And with that, the next bill for our consideration is House Bill 60. Reading clerk, please read the bill.
House Bill 60, sponsored by Management Audit, Fiscal Training and Enforcement of Financial Reporting Laws, an act relating to minimum fiscal procedures, training for public officers. Mr. Speaker, your Committee Number 7, Corporations, Elections, and Political Subdivisions, to whom is referred House Bill 60, Fiscal Training and Enforcement of Financial Reporting Laws, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes: Representatives Blackburn, Burt, Duncan, Ayer, LeBeau, McGuire, Roscoe, Swanitzer. Excused, Representative Clausen. Representative Swanitzer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Swanitzer?
I'm moving the Committee of the Whole rise to report it do so with the recommendation that House Bill 60 do pass. I would further move Standing Committee Amendment Number 1. And quickly, before I turn it over to the Speaker, discuss Standing Committee Amendment Number 1. There was some confusion in the bill where our friends of the counties believed that we gave them the power to wipe out municipalities. Some argument about that, but we certainly didn't want that to be out there, and so we had some clarifying amendments that cities don't have control over taking out municipalities. That's what the amendment does. Ask for your favorable aye.
Question being called on Standing Committee Amendment Number 1. All those in favor, please say aye. All those opposed, please say no. Standing Committee Amendment Number 1 to House Bill 60 has been adopted. We're back on the bill. Speaker Barlow.
Thank you, members. So this is a companion bill to the one we just did, House Bill 56. This is House Bill 60, and this is actually to assist those individuals and governing boards with understanding their fiscal responsibilities, both on the reporting side, but really in the management of the operations. So what you'll see in this is the ability of the state agency. Probably actually this is actually where there's a stick in this, ladies and gentlemen, and I should go to page 2. Page 2, the new language on this basically says, if the applicants are looking for state funds, any of these boards, commissions, counties, cities, etc., if they want state funds, they have to be in compliance with the audit requirements prior to receiving the funds. prior to receiving their next set of funds. So this is the stick to say, hey, folks, we love to support you. We have funds available for you to do the things that are important to you, whether it be water projects or whatever it may be, but you have to be in compliance with your obligations for the audit requirements. You need to be in compliance. So the rest of the bill is about how we get them there, how we actually get them trained, and how we actually support them to get there. So some of it will be the department that's responsible for these audits will have training courses, and they'll also approve training courses that some of your elected officials already have in your county. So the county, so organizations, a clerk's organization or whatever, they have town clerks. They have trainings that they do on behalf of town clerks all over the state. If those qualify, the department will say, yes, you've met your training obligation under this. So this is all about being responsible with the funds and obligating those folks who are responsible to receive training and then take care of those funds in a proper way. So, Mr. Chairman, if there's no questions, I'd be glad to call for the question.
Question being called. All those in favor of Chairman Swaniter's motion that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 60 do pass. All those in favor, please say aye. All those opposed, please say no. House Bill 60 has passed Committee of the Whole. The next bill for our consideration is House Bill 10. The reading clerk will read the bill.
House Bill 10, sponsored by Select Tribal. Tribal Reference Amendments, an act relating to the tribes of the Wind River Indian Reservation. Mr. Speaker, your Committee Number 1, Judiciary, to whom is referred House Bill 10, Tribal Reference Amendments. Respectful reports, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Crago, Larson, Dan, Oakley, Olson, Provenza, Rodriguez, Williams, Washit, Yin, Swanitzer. Representative Olson, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Olson?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 10 do pass, and I further move the adoption of the standing committee amendments. Mr. Chairman, I'll turn over the explanation of the bill along with the standing committee amendment to the representative from the Select Committee that brought this bill forward.
Chairman Larson. Oh, Chairman LeBeau, I am sorry.
Thank you, Mr. Chairman. Members, I bring to you House Bill 10, Tribal Reference Amendments, and would ask for your favorable consideration. I'll move the Standing Committee Amendment Number 1 to House Bill 10 and ask for your favorable consideration. During the interim, the committee modified the foreign language references in Title 21 to include Indigenous languages. But we would like to offer this amendment starting on page 12 of the bill and conforming throughout the rest of the bill, strike the addition of Ordigenous after foreign in Title 21 and add world so the statute would read world languages instead of foreign languages. This amendment makes it inclusive. That is the amendment, and I will stand for any questions.
Question on Standing Committee Amendment Number 1. All those in favor, please say aye. All those opposed, no. Standing Committee Amendment Number 1 has been adopted. Representative, would you like to move the Committee of the Whole Amendment Number 1 at this time as well?
Mr. Chairman, I'm going to go ahead and start a little bit, and then I'll address that at the appropriate time.
At your pleasure.
All right, members. This bill seeks to correct and standardize the statutory references from the obsolete Joint Business Council of the Eastern Shoshone and Northern Arapaho Indian Tribes to the Cooperative Tribal Governing Body, so that this reference, Cooperative Tribal Governing Body, going forward means the Intertribal Council of the Eastern Shoshone and Northern Arapaho Tribes, or its official successor joint governing body. This definition allows for the flexibility of the tribes to change their name if they so choose, but without any name change affecting state statutes and how we, at the state level, reference the tribes going forward. Mr. Chairman, at this time, I'll move Committee of the Whole Amendment Number 1 to House Bill 10 and would ask for your favorable consideration. Friends, what this does is on page 3, line 14, after the word body, inserts, or each tribe as an individual sovereign, which clarifies that the cooperative tribal governing body derives its power from the two sovereign tribal governments. And in the case that the Intertribal Council were to be dissolved, the obligations of that government should pass to each individual sovereign tribal government. And this amendment also cleans up some language in 3 places where the Eastern Shoshone Tribe and Northern Arapaho Tribe are referred to as Eastern Shoshone Tribe of Wyoming and Northern Arapaho Tribe of Wyoming, and merely makes the references to the tribes consistent throughout. This is the amendment, and I'll stand for any questions.
Question being called. All those in favor of Committee of the Whole Amendment number 1 signify by saying aye. Opposed? Amendment is adopted. We're back on the bill.
Thank you, Mr. Chairman. The bill corrects and standardizes any statutory references from Wind River Reservation to Wind River Indian Reservation, and corrects and standardizes any statutory references to either tribe. It corrects the spelling of the name Arapaho with an E to Arapaho without the E, which is the correct spelling, as well as the correction of the name Shoshone with an I to Shoshone with an E, which is their correct spelling. The bill also in statute 36-8-301, starting on page 25 through page 26, adds the word historic, which recognizes an act of Congress when tribal land cessions are being diminished or disestablished. This word is important when speaking about ceded land. Lastly, the bill repeals 9-2, 1901 through 9-2, 1905, which is the obsolete Wyoming Indian Affairs Council. It no longer exists and has not existed for several years. The bill's effective date is July 1, 2022. Chairman, this is the bill, and I'll stand for any questions.
Question being called. All those in favor of Chairman Olson's motion that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 10 do pass, please say aye. All those opposed, please say no. House Bill 10 has passed Committee of the Whole. We are on to our next bill, House Bill 18. The reading clerk will read the bill.
House Bill 18, sponsored by Transportation, Off-Road Recreational Vehicle Registration Amendments, an act relating to motor vehicles. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 18, Off-Road Recreational Vehicle Registration Amendments. Respectful report, same back to the House with the recommendation that it do pass. Ayes, Representatives Baker, Brown, Burkhart, Henderson, McGuire, O'Hearn, Stivar. Noes, Representative Burt. Representative Obermueller excused. Representative Burkhart, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Burkhart?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rise to report it, do so with a recommendation that House Bill 18 do pass, and turn the explanation over to the good representative from here in the capital city.
Representative Henderson.
Thank you, Mr. Chairman. Members, this bill has introduced, recalling last session, we inadvertently left out the phrase requiring annual registration of these vehicles. And so this is a correction. If you look on page 2, it's line 3 and 4, and it reinserts the registration requirement. It says the registration expires annually in accordance with Wyoming Statute 31-206A and upon transfer of ownership of the vehicle. So a fair question would be, what about the ones that have been registered since it was enacted? And so in section 2, we have that covered. And so for those individuals that have done this registration of the vehicle since it was enacted July of 21, they will be in effect grandfathered, if you will. And then when they change ownership of the vehicle, then the new owners will be covered under this update. I stand for any questions. If there are no questions, I call for the question.
Question being called. All those in favor of Chairman Burkhart's motion that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 18 do pass, please say aye. All those opposed, no. House Bill 18 has passed Committee of the Whole. The next bill for our consideration is House Bill 5. The reading clerk will read the bill.
House Bill 5, sponsored by Agriculture, Wild Horse, and Borough Management, an act relating to land management. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred House Bill 5, Wild Horse and Borough Management. Respectful report, same back to the House with the recommendation that it do pass with the following amendments. Ayes. Representatives Kenner, Larson Lloyd, Nicholas, Schwartz, Simpson, Stith, Walters. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Eklund?
Mr. Chairman, I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill number 5 do pass, and I'll
Oh.
turn the,
Mr. Chairman, I'm sorry, I jumped ahead of the reading
we
clerk
didn't have the
here, so.
reading clerk, sorry.
House Bill 5 was re-referred to Agriculture. Re-referred to Appropriations from Agriculture. Mr. Speaker, Committee Number 2 Appropriations to was referred House Bill 5 Wild Horse and Borough Management. Respectfully report same back to the House with a recommendation that it do pass with the following amendments. Kenner, Representatives Kenner, Larson, Lloyd, Nicholas, Schwartz, Simpson, Stith, Walters. Ayes. Representative Nicholas, Chairman.
Now you've heard the reading of the bill. What is your pleasure, Chairman Eklund?
Yes, Mr. Chairman, we're still shaking off rust. Mr. Chairman, I move that when the committee of the whole rises to report, that it do so with the recommendation that House Bill 5 do pass, and I'll turn the explanation over to our committeeman who resides in the county with the springs that run hot.
Representative Winter.
Yes, thank you, Mr. Chairman. Ladies and gentlemen, this bill was created as an effort to get the attention of the federal agencies who are charged with the responsibility to properly manage these wild horse populations in Wyoming. Herd populations have been established by these federal agencies, but these agencies have ignored their mandate to manage the horse numbers. But however, probably the most important objective is to save the range resource out there. Ladies and gentlemen, this is for the last 5 to 7 years, there's been a drought down there on the desert in the southwestern Wyoming. And it's really affected the range condition down there. We are close to losing this range resource. And in that country, the rangeland is right at 50% private and state. The other 50% is federal land. And in addition to the wild horses out there, there's a number of domestic livestock which are also permitted to be there for a period of time during the year. However, the horses that are there, they're 365 days a year, and they tend to control the water sources and keeping many of the authorized livestock away. It is very difficult to get meaningful management on these horse populations. This bill will allow the Office of State Lands and Investments to assess the grazing costs of these horses to the Department of Interior and Agriculture for reimbursement. Upon the failure or refusal of the U.S. BLM or Forest Service to remove any wild horses claimed by these agencies, these horses which regularly stray from the federal lands will be that are on these federal lands and stray onto private and state lands. The Office of State Lands and Investments shall provide the Secretary of the Interior and Agriculture as applicable with annual notice identifying the grazing costs for these wild horses and a request for reimbursement of these costs. In addition, if these wild horse numbers are in excess of the high appropriate management levels, an amount equal to 3 times the land lease rate per animal unit month for Wyoming will be charged 3 times the land lease rate per animal unit month from the Wyoming or for the Wyoming Trust land grazing leases. The Attorney General may seek a writ of mandamus to compel the BLM or the Forest Service, as applicable, to take action to remove excess horses as required under federal law from non-federal lands, recognizing that wild horses roam without regard to political boundaries, and they're trespassing on these non-federal lands. The governor is authorized to enter into cooperative agreements among state and local agencies and with the United States BLM and Forest Service, as well as the Eastern Shoshone Tribe, the Northern Arapaho Tribe, and official cooperative tribal governing bodies, adjacent states, non-governmental organizations, or other private entities. A cooperative agreement under this subsection may provide for any cooperative undertaking to manage wild horses, including population reduction tactics, permanent and temporary fertility control techniques, expanding or increasing the number of wild horses training and adoption programs, and other removal activities. Also, there is appropriated $2 million from the general fund to the Office of the Governor for state endeavors to manage horses in the state, including on the Wind River Indian Reservation. That's it, I guess. I stand for any questions you might have.
Chairman Flitner.
Mr. Chairman, thank you. I was a no on introduction, and the reason is I have no qualms with the need for management of and reduction of numbers of wild horses. But my fear is that the state could get drawn into the same problem that we have at the federal level, and that is that we are now in the business, or could be in the business, of managing wild horses. And I wonder if the committee had that discussion, and yeah, if I could get an answer on that. Thank you.
Representative Winter.
If I heard the good representative correctly, she's got a good point. But I think we have to encourage our governor, or encourage the executive in this state to take a stand and really put an effort out to pressure these federal agencies to do their duty.
Chairman Olson.
Thank you, Mr. Chairman. To the good Committee on Agriculture, and maybe I just missed this in the presentation of the bill, but what is the total cost to the general fund to manage these wild horses and burros? And then what is the cost to, because I understand that there are multiple levels of government that would be involved here. I mean, the tribal governments would be involved and local governments. And is there a cost to the tribal governments? What does that look like? And then on the local level, what does that look like? Thank you, Mr. Chairman.
Representative Clausen.
Thank you, Mr. Chairman. I'll take a whack at that. So currently the horses are managed under the Wild Horse and Burro Act, and it's all done federally. On BLM land, the problem is that we're trying to correct here is the checkerboard in state lands where horses stray off, and the numbers were roughly twice what the carrying capacity could be. On the reservation, they have a little different issue. They have almost estimates are somewhere between 15 and 20,000 feral horses. They don't belong to they don't fall under the Wild Horse and Burro Act, but they could use some state help in gathering some of these horses, and that's what this is directed at.
Representative Ottman.
Thank you, Mr. Speaker, Chairman. I just wanted to say with the Wild Horse and Burro programs, they've been very, very active since the 70s. And one of the things is that they were supposed to be in effect until a certain number. With the way that it's been managed, there's a lot of people who are given opportunity to take care of these animals and put them on range or to buy it. And a lot of times that ends up being very close to a feedlot. The other thing is that I have seen some legislation around here going to look at possibly making more on kind of thank you. Let me see, what will I say? Prison Corrections Institute programs, which the programs in themselves are wonderful, but to multiply and multiply the amount of the horses. We as legislature, I believe, are charged to take care of the public lands or provide the opportunity for the public lands to be taken care of. And they are being overgrazed. If you've ever had a horse, you know that they will eat 24/7. They will not stop. And so if they are crossing over those boundaries to private property or to other lands, we need to be aware of that and take some actions. Thank you.
Representative Banks.
Thank you, Mr. Chairman. Just a question. This is obviously a big issue in my neck of the woods. Will we rely on the BLM's count of those horses, or will the state then do an annual count as far as knowing what that herd size is and how much to bill for and all of those questions? Because that could obviously get very expensive. Thank you.
Representative Winter.
You want me to answer all those questions? To answer the good representative from the Red Desert, I can't remember the question now. I'm getting all kinds of direction here. Yeah, why don't you?
Chairman Eklund.
So to clear up a few of the things, and I know that we're short on committee of the whole time. The best part of this bill was that we brought together a whole group of people that agreed that we need to get proper management of the horses and get a handle on what's going on. We had the conservation groups at the table with us. We had the tribes at the group with us. We had the BLM. We had the other land managers, private and otherwise. Probably the strongest message we can give the federal government, or the strongest thing we can do, is a writ of mandate, which is, have you ever tried billing the federal government? Well, it's kind of that way. And with a cost estimate of what it costs. The costs to the state of Wyoming are primarily the feed costs. We don't take care of the captured horses. That's a federal government's cost, and I think it's 50-some million dollars a year, as I recall. But out of the general fund, there is nothing. This $2 million will be used to gather some of these horses, and I'm trying to think all the questions that were asked, but that answers a bunch of them. If there's more, go ahead and fire away.
Chairman Nicholas.
Thank you, Mr. Chairman. I would move the Standing Committee Amendment number 1 based on re-referral, and turn the explanation of the amendment over to the good representative from Casper.
Representative Walters.
Thank you, Mr. Chairman. So Standing Committee Amendment, I think it was number 1, came from the Committee number 2 Appropriations. And what we have done is we have removed the $2 million and that section of the bill. And the reason we have is because the federal government, these horses and burros are currently managed under the Wild Horse and Burro Act, which means that they are the responsibility of the federal government. The federal government is spending millions, hundreds of millions of dollars a year, to where this $2 million really isn't going to effectuate much. Furthermore, it doesn't really even spell out in here other than to say for the governor of the state, the office of the governor for the state to endeavor to manage wild horses. So there is nothing here that really tells what we're going to do with this $2 million, and the appropriations our group, we really just felt like we were throwing money in the wind here at this, and so didn't feel like it was a good approach. I think the best approach would be if and when the state is able to enter into an agreement with the feds to manage these horses, then we would know what the expense we expect, and we could start down that path. But to just start throwing money at it, at something that we have no control over what we do to begin with, the committee felt that that was just not a wise use of general fund resources. Please vote yes on the amendment.
Chairman Greer.
Thank you, Mr. Chairman. With respect to the amendment, just curious, read the bill and, so I get to say this, so my education wasn't wasted, but there's a right for the state to seek a writ of mandamus. So those aren't going to be cheap. A writ of mandamus is a court order for an inferior, I don't know if that's the right word, official to do their duty. So, I mean, could those funds be used for litigation expenses in that vein?
Chairman Nicholas.
So, thank you. Just to respond to that question, theoretically it could, but that's literally the function and the duty of our Attorney General. That's why we have 92 lawyers who work. Actually, I think it's more than that now, plus additional staff to bring that type of litigation. And recall we're a fence out state, number one. So whoever has the lease on those private properties, it's their obligation to fence out the wild horses. And the only way to really, so I don't think we want to use state money to help private owners or lessees fence out the burros. And so we need to know what the money was going to use for and how they came up with the money to understand how we're proceeding with this. So that's the rationale for the good appropriations, folks.
Representative Clausen.
A little confusion. So there's two separate parts of this. So the wild horses on the BLM are managed by the federal government, and that's true. Wild horses on the reservation are not. And they reached out to this committee to get a little help with some of these gathers. They're destroying massive amounts of wildlife habitat, bighorn sheep habitat, and have become a major problem. So part of this appropriation was intended for that.
Vice Chairman Larson.
Thank you, Mr. Chairman. And my understanding from the superintendent of the Bureau that handles Indian Affairs in our Select Tribal Relations conversation is there may be some wild horses, but most of the horses, and there's around 14,000 that are mostly strays and abandoned horses that they've just turned loose and are running around there. They manage them. They have been hauling them up to Canada, rounding them up and hauling to Canada. It's a big problem. It's a really big problem. But the majority of those are not what we would deem wild horses.
Chairman Olson, on the amendment?
On the amendment, Mr. Chairman, so with, I need a little clarification. So now with no appropriation, does the Office of State Lands and Investments just absorb the cost of the notices that it sends to the federal management for the grazing lands?
Representative Walters.
Thank you, Mr. Chairman. I think there's several agencies that can help absorb these costs. These are things that these agencies take on to begin with. First, in the executive's office, there's the FNRPA account, Federal Natural Resource Policy account, as we are talking about natural resources that are being affected here. We have the Attorney General's office that can do this sort of work and does this sort of work, maybe not on wild horses just yet, but they work on these federal issues on a regular basis. Additionally, OSLI does this kind of work. They do have a budget for sending out notices. They also partner with the AG's office to get work done when they need those legal sides of things. So I think within our existing structure in state government, there is already funds available, and just fear that this is $2 million that we'd never see back and see very little rate of return on, when there is already money in all of these budgets that could take care of this. I'm not discounting that there are certainly issues with the wild horses and burros throughout the state, but to throw $2 million at a problem that the federal side is already spending hundreds of millions of dollars annually. I'm just not sure we're going to accomplish a whole lot, especially knowing that these are still federally managed species that the state really doesn't have any control over currently, and that would be the first thing that needs to be handled. And then after we get down that road, I think it's maybe appropriate to come back and look at appropriations when we have a defined purpose for these appropriations. But when all you're saying is to endeavor to manage the wild horses, that's such a broad, wide open term. I just fear that that these dollars would be lost and lost forever, and this is just not a wise use of these funds.
Chairman Nicholas.
Thank you. And just to follow up on that, the question is what work? I mean, when you read the bill, we don't know exactly, other than to assert that they're being mismanaged by the federal government. What else, other than filing a writ of mandamus, does the governor's office do? Are they going to hire wranglers and clear them off of private lands or off the reservation? I mean, we have no idea what the money's even for. So, and until we know, it doesn't make sense to us put a pot of $2 million just sitting there in the governor's office.
Any more discussion on the amendment? Question being called on Standing Committee Amendment number 1. All those in favor, please say aye. All those opposed, please say no. Standing Committee Amendment number 1 has been adopted. We are back on the bill. Any further discussion? Representative Yen.
Mr. Chairman, thank you. So on the fiscal note, I know we just struck out the $2 million, but it creates a new unit. Are we still creating this new unit of government with the bill? And will they be coming into the budget the next year once they've started creating these agreements with local and other agencies? So are we creating more government with this bill? That's my question. Thank you, Mr. Chairman.
Representative Sweeney.
Thank you, Mr. Chairman. So I'd urge your support. I know this doesn't make a lot of sense to a lot of us, but truly there's a problem. We know there's a problem. It's really taking away from habitat from other wildlife, and the feds really aren't doing a great deal that I can tell, and I would urge your support.
Any further discussion? Representative LeBeau.
Thank you. I rise in support of this bill. We, on the reservation, have a feral horse problem. Again, like my good chairman said, it's a lot of strays, and it is affecting critical wildlife habitat. And the Bureau that oversees Indian Affairs have been failing their obligation to curb this problem that we have on the reservation. I would support this bill because we don't hunt or eat them, and it is comparable to our elk herds that are on the reservation as well. So it's hurting those critical wildlife habitats for our elk and for our deer as well. So I support this legislation and I urge an aye vote. Thank you.
Chairman Eklund.
It's the intention of the Mr. Chairman, it's the intention of the committee to have the state step in and take over some of the responsibilities that are not being taken care of by our federal government. There are very few wild horses. Most of them are feral. There's no distinction being made by the federal government on probably any of the herds that are managed throughout the U.S., sort of managed throughout the U.S. They're all primarily feral horses. These horses that were on the reservation were managed in a way to try to keep a healthy herd. It's been taken out of the hands of the people that did that. And there's a few other little places here and there, but the Office of State Lands would probably be one of the agencies. There's the NRCS and there's other local agencies that can determine the damage done to the rangeland and see if we can't get compensation for these people who are being harmed by the lack of action by the federal government. And it's across the board, everybody interested in these horses including the conservation groups, wants something done. It's not being done by the federal government. We're hoping that the state government can intervene and help in this situation. With that, I'd move an aye vote on this bill.
Any further discussion? Representative Ottman.
Yes, Mr. Chairman, just to reiterate what all of the previous speakers have said, this bill, I am in support of it because it's the setting up of taking action to remedy a problem that's very serious for our state. It's not just one entity or one group of people that are going to be affected. It crosses all bounds and so many agencies. This says that it's requiring a notice, okay? Not a whole bureau, just a notice. And also authorizing enforcement. So it's authorizing, it's not enforcing, it's authorizing enforcement by the people that already are in charge of these issues. It also says providing for state with the tribes. The tribes are on board there, and we have where the chairman and the president of the two tribes would of course be involved in that. And then just to have everybody come together on a consensus and talk like the other representative was saying, a consensus to say, okay, we've got a bill, we've got the authority to get moving on this, let's do it. So I would just ask you to vote yes.
Any further discussion? Question being called. All those in favor of Chairman Eklund's motion that when the Committee of the Whole rise to report, it do so with the recommendation that House Bill 5 do pass, please say aye. All those opposed, please say no. House Bill 5 has passed the Committee of the Whole. I'm going to take just a quick pleasure here, own personal pleasure. I would like to recognize in the West Gallery, if you would all mind standing and welcoming Mr. Parker Gronsky here. He is a House District 9 constituent as well. You may recognize his mom as well. Welcome to the House. And I will also state for the body, that one bill took as much time as the previous 13 bills combined. So we can keep on moving on. So the next bill for our consideration is House Bill 146. The reading clerk will read the bill.
House Bill 146, sponsored by House Appropriations. General Government Reports, an act relating to the administration of government. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred House Bill 146, General Government Reports. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Kenner, Larson Lloyd, Nicholas, Schwartz, Simpson, Stith, Walters. Representative Larson, Vice Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Nicholas?
Thank you, Mr. Chairman. I move when the Committee of the Whole rise and report it does so with a recommendation that the bill do pass, and turn the explanation over to the good representative from up north.
Representative Kenner.
Thank you, Mr. Chairman. Ladies and gentlemen, I'll just refresh your memory from our discussion the other day on introduction. This is sponsored by your Appropriations Committee, and it deals with general government reports. And so I'm not going to spend too much time on it, but as you might imagine, we do want to monitor certain things once we do make appropriations. And so this gives us the tool to do that. I guess that's all the comments I wanted to make, unless someone had some specific questions on the bill.
Question being called. All those in favor of Chairman Nicholas's motion to that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 146 do pass, please say aye. Those opposed, please say no. House Bill 146 is passed Committee of the Whole. The next bill for our consideration is House Bill 131. Reading clerk, please read the bill.
House Bill 131, sponsored by Representative Burkhart. Nuclear power generation and storage amendments, an act relating to environmental quality. Mr. Speaker, your Committee Number 9, Minerals, Business, and Economic Development, to whom is referred House Bill 131, Nuclear Power Generation and Storage Amendments, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes. Representatives Burkhart, Duncan, Air, Greer, Heiner, Western. Noes. Representatives Bear, Gray. Excused, Representative Sherwood. Representative Greer, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Greer? It's 146.
It's 131, right?
131, I'm sorry.
Yeah, Mr. Chairman, sorry. I move that when the Committee of the Whole rises report to do so with the recommendation that House Bill 131 do pass. There is a standing committee amendment, and I'm going to turn it over to the sponsor of the bill, fine gentleman from Rollins.
Chairman Burkhart.
Thank you, Mr. Chairman. I think I'll handle the standing committee amendment as we go through the bill. That's just easier. Ladies and gentlemen, we talked about this bill on introduction, and it really is about keeping jobs in Wyoming and providing for jobs and that. And it talks about our current nuclear generation standards, statutes, and that. It's easy to understand this bill if you look at it in three sections. The first being existing statutes on spent fuel rod storage. There was a time when this body passed legislation on fuel rod storage, which really doesn't apply in this matter. It mentions reactors, nuclear power in the realm of the fuel rod storage, and there are some problems with that. One, that the federal agency that licensed nuclear reactors feels that Wyoming overstepped its bounds and interferes in their preemption of those actions. Additionally, in that section, which is 31 or 3311, 1500 or Title 15, part of that requires that the United States have a permanent repository for spent fuel rods, which it'll probably never happen in all reality. So we need to address that issue to allow it to continue and to follow that agency's requirements on storing spent fuel. And that's what the first portion of this does. Corrects those things in section 3511 1506E. And that's so that we address those preemption issues. The second part is, and some of you I know are here, there was legislation passed to encourage building small modular reactors in Wyoming. And so the bill goes in and changes that language and that information to advanced reactors, of which small modular reactors are part of that. They're all advanced reactors. The best way to understand an advanced reactor is that it is not one of these large facilities that you picture being built. They're much smaller, much more compact, use different materials, different fuel, and that sort of thing. And that's a way to look at it. We've corrected those issues, and again, have addressed the issue of preemption with the federal agency. The third part is to allow a company to install a nuclear reactor to either replace or augment existing power plants, coal, natural gas, that sort of thing, and to site them nearby so that they can make use of the infrastructure existing for the power plant, which saves a lot of money. So those are the things it does, and it also addresses that issue of preemption. If you remember that bill from past sessions, and the bill that talked about having to sell them, they don't have to offer for sale a plant they want to put a reactor in. And that. So that's kind of the bill in a nutshell. While we do change some things on industrial siting, we require reports be given to our department that addresses environmental issues. Excuse me. While we rely on the NRC doing the federal agency that administers these to do the legwork. They conduct a much more robust review than we ever would, we being the state. They put a lot of effort into it. They look at things that normally would not be considered in an industrial siting review, such as the geology of the area. They also include numerous other federal agencies that administer wildlife, the environment, water, socioeconomic issues, and that. And if you want to see it, I have multiple pages of the process they use. I could stand here, but I know that other people want to present their bills and that. So, and the requirements to produce reports give our department in charge of these issues and the environment the information they need to watch out for the state. So that's it in a nutshell. I'll address at this point the standing committee amendment. And if you look at page 3, line 19, it adds in a requirement that the company building one of these will tell the state of Wyoming what number of jobs would be filled by Wyoming residents. And I think that's an important thing we need to know. We're talking about jobs. Let's find out how many they need. That's then carried over on page 6, line 18, and that with the same language. And with that, and we renumber to be consistent. So with that, I'd ask for your aye vote on Standing Committee Amendment number 1.
Standing question being called on Standing Committee Amendment number 1. All those in favor, please say aye. All those opposed, no. Standing Committee Amendment number 1 has passed. We also have a Committee of the Whole Amendment. Representative Burkhart, or Chairman Burkhart, are you done with your explanation?
At this point, I would say yes. I'll stand for questions.
Representative Sherwood.
Thank you. Thank you, Mr. Chair. I move Committee of the Whole Amendment number 1 to House Bill 131 and ask you for your favorable consideration. This amendment creates a sunset for the tax exemption for electricity generated by an advanced nuclear reactor on or after July 1 of 2035. This gives new projects 13 years to get up and running while providing us, the state of Wyoming, time to measure the return on investment of that exemption. Not having seen justification on why this exemption is needed, I am highly suspicious of writing a blank check that goes on indefinitely for any industry. While this amendment does not address the $5 megawatt per hour fee nuclear pays on the production of electricity, I hope that you will agree to this sunset and then encourage an interim topic on our energy tax structure that would holistically consider tax rates across all our power producers. Thank you for your consideration.
Chairman Burkhart.
Thank you, Mr. Chairman. Ladies and gentlemen, I'd ask you to resist this amendment. It does more than just put a sunset in. It starts talking about test reactors, demonstration reactors, and those sorts of things without any definition of what those words mean. You could probably take any facility, coal-fired power plant, for example, change a few things and call it a test or demonstration plant. And the same goes for this. You could make it a test of any kind. You could try to exceed the power limits and say that's a test. Demonstration, I'm really not sure what demonstration means. Not well defined even in the current federal standards. So I'd ask you to resist this amendment.
Representative Sweeney.
Are we on the amendment?
We are on the amendment. Representative Yin.
Thank you, Mr. Chairman. So I was in the committee that took the original bill that this language comes from, that it's being modified by this bill. So I was on House Travel, and we had this advanced modular nuclear reactor, and we did add a tax that the body decided was appropriate. This exemption was specific for test and demonstration reactors. So it was the idea that we would incentivize these people to test in Wyoming. You could have the exemption while it was testing, but once it's in full-scale production, we wanted to make sure that this energy source, just like we tax other energy sources, is fairly taxed. Otherwise, if you permanently exempt advanced nuclear reactors forever, they get essentially a subsidy because their nuclear generation isn't taxed while we tax basically every other energy source. So I do think that the very important part of this amendment is the last part, which is sunsetting it, because right now in the bill, we just exempt these reactors completely. So even if they create this power plant and are permanently installed. It's no longer a test or demonstration. It's a long-term business. We're not taxing them, and I don't think that's appropriate. So I would ask for an aye vote on the amendment. Thank you, Mr. Speaker.
Chairman Burkhart.
Mr. Chair.
Thank you, Mr. Chairman, and I will disagree with that statement. We don't tax every other energy source. For example, there's no tax on solar. Maybe a mistake by this body. And if we want to talk about taxes, I think we need to have a uniform approach to all of that and not just pick and choose. And that's something I think that maybe our Good Revenue Committee or one of the others could consider in the interim, is looking at all of those taxes and how we do it. For example, most likely a lot of power plants at some point will be converted to hydrogen or ammonia power, considered very climate friendly, and there's no tax on those. And one problem there would be is hydrogen would be produced from our water, and hopefully from some of our other resources. We don't have the water to give up, so I don't know how you would tax that. And remember, with these reactors, they pay sales tax. They pay property tax. They pay ad valorem. The uranium that goes into them pays severance tax. There is quite a bit of tax money that'll come out of these. And I would ask you to resist the amendment again.
Vice Chairman Duncan.
Thank you, Mr. Chairman. We heard a lot of testimony just on this too. So I would urge a no vote. We need to get this in place so that we can get this program going and we can starting to get some jobs and revenue going. So I urge a no vote, and let's say aye for the bill.
Representative Gray.
Mr. Chairman, I'd really urge an aye vote on this amendment. You look at all the federal money they're getting, the federal grants, the tax credits. I mean, this project is, I legitimately want to ask them, but I don't know how you'd calculate this. How much of your own equity are you putting into this project? I mean, I would not be surprised by the end of this if we're paying for, I would say, over 60 to 70% of this project. And then on top of that, they want this state tax exemption. I mean, this is like a walking giveaway, this project. I would do a lot more than this amendment. I think it's pretty low key to say 2035, but let's at least put this in place. And I encourage an aye vote. Thank you.
Representative Yin.
Mr. Chairman, so just a reminder, this amendment is just a sunset, essentially, 2035, so it lets them get started. And if for some reason we really do need to exempt them from this tax, then we could do it before that sunset date. I think this is a good compromise and also ensures that we don't put in uneven ground where we're taxing other energy sources more than others. Thank you, Mr. Chairman.
Chairman Burkhart.
Thank you, Mr. Chairman. The private equity in this from the company is about $1.2 billion.
Question on the amendment, Committee of the Whole Amendment number 1. All those in favor, please say aye. All those opposed, please say no. Committee of the Whole Amendment number 1 has been adopted. We are back on the bill. Chairman Burkhart. Division being called. All those in favor of Committee of the Whole Amendment number 1, please rise. All those opposed? The amendment has failed on a 26-26 vote.
We are back on the bill. Chairman Burkhart.
Mr. Chairman, seeing no one else at the mic, oh, I apologize.
Representative Yen.
Apologies, Mr. Chair. So I did have one question. There are repealers, and I think they are for siting of nuclear waste storage, and I just wanted to understand what the conversation about repealing some of those siting provisions were. Thank you, Mr. Chairman.
Representative Heiner.
Thank you, Mr. Chairman. Members, this demonstration plant will be in my district, and we did a survey in the communities which would be affected. There was 85% in favor of this demonstration plant. These people will live right there close by. I know you've seen a lot of public input where there's some people very vocally saying that we shouldn't allow this come to Wyoming from very far away that are opposed to it. But those that are living right there, 85% say, yes, let it happen, let it happen. And the chief executive officer that offices just below this chamber, he repeatedly talks about all of the above energy solutions for Wyoming. This is one of those all of the above. Let's let it play out. Let's pass this bill. There may be some things that we need to tweak a little bit, but we're still 7 years away from this thing going into operation. There's a tremendous amount of licensing studies that have to be done, but let it play out. Let's not get in the way of progress in the state of Wyoming, in the way of business, as we try to divest and go into different areas. Now, some say that the uranium won't be coming from Wyoming, so why should we do this? Well, not right now, but if it develops into a viable industry, then we sit on some of the best deposits of uranium here in Wyoming. But we won't know if it's viable until we let this demonstration plant happen. So I urge your aye vote. Let's let this play out here in Wyoming. Thank you.
Members, before we continue on with more debate, just a quick reminder, you have less than 1 minute to finish off your third reading amendments for the budget tomorrow. They are due by 5 o'clock, so if you have any outstanding, please make sure you get those in. Chairman Burkhart.
Thank you, Mr. Chairman. On the issue of repealers, what is repealed is 3511-1506E, Romanet I through Romanet V, and that's what we've repealed is the portions that cause the Federal Nuclear Agency to have problems relative to what they feel is a preemption issue. We have an interpretive letter from them. And it's replaced, if you go to page 2, by that information on page 2, on page 3, on to page 4, in a way that does not affect that preemption and still provides Wyoming with the information it needs.
Representative Gray.
Thank you, Mr. Speaker. I wanted to provide a little more insight on how this is adjusting state statute. It's not in the repealers responding to the member from District 16, but I want to highlight something that this changes that I think may be something he might want to, was kind of asking about, which is that current state statute says that before this type of facility is permitted for nuclear waste storage, there would have to be a long-term storage plan for our nation, which we have been unable in our political paralysis to get done for 4 decades. The proposal at Yucca Mountain in Nevada is totally not going to happen. It got sunk into 2 presidential elections at the start of the millennium, and it's just not going to happen. And it's pretty much been totally abandoned. And what this does is basically amend state statute to say they don't need to have that long-term plan anymore, which means they're going to store the waste at the site indefinitely, in my opinion, forever, because I don't think there's ever going to be a solution. I know there's some Illinois repository they're talking about, but they don't have to contract out with that Illinois repository. They don't have to do that. So, I mean, it basically is going to sit there forever, and this amends state statute to allow for that indefinitely. Thanks.
Chairman Burkhart.
Thank you, Mr. Chairman. So this is not a bill on nuclear waste storage. It's mentioned, the reactors are mentioned in that section, and I don't want to confuse the discussion here. 35, 11, 1500, all of those were written, if I remember correctly, in the mid to late 90s when Wyoming was looking at a commercial spent fuel rod storage site in the state. Later on, and I believe it was in the mid 2000s, the statute was amended to include mention of a nuclear reactor in case one was ever built. And that the way the statute is written is the problem, not the storage, because it would require that this repository exist before the state would have a reactor. And the intent of the bill is to allow the reactor to come in, or maybe multiple ones, and be installed and go into operation, and that the fuel rods will be stored on site as they are on every nuclear power plant in the country. And I could go into great detail on the storage, but I can tell you this, long-term storage would appear no different than, say, a tank battery at a producing well site. In fact, they're cool enough, snow doesn't melt on them. I've seen that. So this just allows us to proceed forward without interference from our own statutes, and that which were written in a kind of an odd manner at the time.
Representative Heiner.
Thank you, Mr. Chairman. Many times when there's a project that comes about, we're all excited. There's an opportunity for Wyoming. We say, yeah, we like wind, but not in our backyard. We don't want to see those windmills. We like solar, but not by my house. We don't want it in our backyard. The people in this community said, yes, we want nuclear. We understand there will be waste, and we understand it'll be in our backyard. So 85% of them says, yeah, we know there's going to be waste stored here, possibly forever. But they trust that it will be taken care of in such a manner that it won't be endangering their lives. So they said, 85% of them said, yeah, do it in our backyard. We're okay with that. Thank you.
Question being called. All those in favor of Chairman Greer's motion that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 131 do pass, please say aye. All those opposed, please say no. House Bill 131 is passed Committee of the Whole. We are on to our next bill, House Bill 81. The reading clerk will read the bill.
House Bill 81, sponsored by Representative Burt. Operation of motorcycles, disabled persons, an act relating to motor vehicles. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 81, Operation of Motorcycles, Disabled Persons. Respectfully report, same back to the House with the recommendation that it do pass. Ayes. Representatives Baker, Brown, Burkhart, Burt, Henderson, McGuire, O'Hearn, Stivar. Excused, Representative Obermueller. Representative Burkhart, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Burkhart?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with a recommendation that House Bill 81 do pass, and turn the explanation over to the good representative from the county with the nice water.
Representative Burt.
Thank you, Mr. Chairman. Ladies and gentlemen, before I kick off, I did send an email out about 10, 15 minutes ago. If you take a look at that, it might help put into context what I'm referring to when we talk about motorcycles that are designed for disabled riders. So if you have a minute, take a look at that and maybe you can help follow along. So this is a fairly simple fix-it bill that addresses an inequality we have within our state statutes. Current state language does not directly prohibit disabled riders from riding motorcycles, but it does, however, prohibit the ability for disabled riders from riding specially modified motorcycles within our states. In the intent to try to keep this simple, I don't want to spend too much time, although I will obviously answer questions if we have any. We'll go through the bill really quick on the section 1, A and B, as well as K. What it really does is it just defines how we're able to sit on a motorcycle. Current law requires us to sit astride, which is basically one leg over the seat. And making these changes, what it does is it allows those that have specially modified seats that can't sit over a seat like that to basically sit in that. And actually, in K, when you look at that, when it talks about actually strapping yourself in, what this refers to are those that may not be able to hold themselves in to actually have a seatbelt, or if they have a motorcycle mount within their vehicle, to actually strap it in there so it doesn't shift upon riding. And those are the cleanups on the language and how we actually ride on that. Section 2 is a repealer of current law. And then Section 3 is the effective date. With that, like I said, without taking up too much time, I'll stand for any questions. If not, I call for the vote.
Question being called. All those in favor of Chairman Burkhart's motion that when the committee of the whole rises to report it, do so with the recommendation that House Bill 81 do pass, please say aye. All those opposed, please say no. House Bill 81 is passed committee of the whole. We're on to our next bill, House Bill 110. The reading clerk will read the bill. The chief clerk will read the bill.
House Bill 110, sponsored by Labor, Board of Psychology Behavior Analyst Regulation, an act relating to professions and occupations, providing for the licensure occupations, an act, be it enacted by the legislature of the state of Wyoming. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom was referred House Bill 110, Board of Psychology Behavior Analysis Regulation, respectfully report same back to the House with recommendation that it do pass with the following amendments. Ayes, Representative Conley, Flitner, Hallinan, LeBeau, Ottman, Romero Martinez, Stivar, Worf, Wilson. Signed, Representative Wilson, Chairman. This bill was re-referred to committee number 2. Mr. Speaker, your committee number 2 appropriations, to whom is referred House Bill 110, Board of Psychology Behavior Analysis Regulation, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Kinner, Larson, Lloyd, Nicholas, Schwartz, Simpson, Stith, Walters. Signed, Vice Chairman Larson.
You've heard the reading of the bill. What is your pleasure, Chairman Wilson?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 110 do pass. I further move the adoption of the standing committee amendment. It was really tempting to ask to divide it, but you'll see that it is a misplaced comma. Please vote aye.
All those in favor of standing committee amendment number 1, please say aye.
Aye.
All those opposed, no. Standing committee amendment number 1 has been adopted. Back to you, Chairman Wilson.
Thank you, Mr. Chairman. For the explanation of this excellent bill, I will turn it over to my good friend from House District 54.
Vice Chairman Larson.
Thank you, Mr. Chairman. Folks, behavioral analysts, we serve in our state. They help in school districts develop IEPs for kids with behavioral and special education needs. We have them serving and working at the State Hospital, Life Resource Center, helping individuals with behavioral challenges better adapt to their environment. These are folks that have a postgraduate degree like a master's in psychology or counseling, social work, those types of advanced degrees. We have them working in the private sector, providing consulting services back to school districts and other sources. And in 2019, as we were completing the construction on the State Hospital Life Resource Center, those administrators under these new mission had applied to the department that oversees our positions and suggested that they were going to need some additional behavior analysts. They were told at the time that we don't have behavioral analysts in Wyoming. There's no licensure for them. They don't exist. And they says, but let us check. And so they went back and checked in our statutes, and the only reference that we have to behavior analysis is in the Psychologists Act. And so they come back and they says, it's there. We understand how we operate now, but as we read the statutes, if we're going to conform to statute, anybody doing behavioral analysis needs to be a doctor of psychology. And that was a little bit problematic due to the availability of psychologists and the costs associated with them. And so that they worked around that. They kind of went and got an AG opinion. The AG come back and with the same opinion. I was contacted by the superintendent of one of the state institutions saying, is there anything we can do to resolve this? I reached out to the Board of Psychology and wondering what their position was, and they says, we get it. They do not need to be doctors. They need to have this advanced degree, and we know that they don't have a licensure act. We think that it would be most appropriate to have them in our act. And so we reached out to the behavioral analysis who are board certified. There's a national board certification for them. And we worked with their organization. We worked with A&I and the Board of Psychology and the Psychologists Association, both nationally in the state. And we brought these behavioral analysis, the board certified behavioral analysts and assistant CBAs into the Psychology Act. We've changed the psychology board to accommodate two positions on that board of behavioral analysis, and then we make it with staggering terms, and then meaning the terms that they serve, and then we accommodate for this initial appointment that they don't have to be licensed in Wyoming until they've been able to complete this and then move on. And so, folks, this is, we're kind of in a little bit of a pickle with our ability to provide these services without the Licensure Act, and hope that you would support this and would be happy to answer any questions.
Question being called. All those in favor of Chairman Wilson's motion that when the Committee of the Whole rises to report it, do so with a favorable recommendation. All those in favor, please say aye. All those opposed, no. House Bill 110 has passed Committee of the Whole. The next bill for our consideration is House Bill 107. The reading clerk will read the bill.
House Bill 107, sponsored by Representative Simpson. Water State Revolving Funds and Amendments. An act relating to the State Water Pollution Control Revolving Loan Account. Mr. Speaker, your committee number 2, Appropriations, to whom is referred House Bill 107, Water State Revolving Funds Amendments. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Kenner, Larson-Lloyd, Nicholas, Schwartz, Simpson, Stith, Walters. Representative Larson, Vice Chairman.
You have heard the reading of the bill. What is your pleasure, Vice Chairman Larson?
After I turn my mic on, Mr. Speaker, I move that House Bill 107. I move House Bill 107, Water State Revolving Fund Amendments, and ask for your favorable consideration. And I would turn the explanation of the bill over to the noble engineer from the Valley of Stars.
Representative Simpson.
Thank you, Mr. Chairman. Folks, the three agencies which administer the Clean Water State Revolving Loan Program and the Drinking Water State Revolving Loan Program has asked us to assist them in adjusting the statutes to more effectively receive and manage the federal funds that are coming our way in the next 4 years. You have read the bill. I believe it's straightforward. I encourage an aye vote and stand for any questions.
Question being called. All those in favor of Vice Chairman Larson's recommendation that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 107 do pass, please say aye. All those opposed, please say no. House Bill 107 has passed Committee of the Whole. The next bill for our consideration is House Bill 76. The reading clerk will read the bill.
House Bill 76, sponsored by Representative Duncan. Single Office Real Estate Brokers Licensing Requirements. An act relating to professions and occupations. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom was referred House Bill 76. single office real estate brokers, licensing requirements. Respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Blackburn, Burt, Duncan, Air, LeBeau, McGuire, Roscoe, Swanitzer. Excused, Representative Clausen. Representative Swanitzer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Swanitzer?
Thank you, Mr. Speaker. I move in the committee of the whole rise to report to do so with the recommendation that House Bill 76 do pass. There are no standing committee amendments, and I would turn it over to the good Vice Chairman of Minerals. There is an amazing standing committee amendment we put on, and I would also let the good Vice Chairwoman of Minerals handle a standing committee amendment.
Would you like to move it for me, Mr. Chairman?
I moved it.
All right. Vice Chairman Duncan.
Thank you, Mr. Chairman. So let me go through real quick, give you an overview, and then I'll tell you what the amendment does. So this bill simply clarifies the intent of the original 2017 legislation, where a company can operate 3 businesses. However, a sole proprietor isn't required to have 3 separate licenses unless they operate an additional brick and mortar business. The current commissioner has sent $300 invoices to sole proprietors. With the passage of this bill, the commission will credit those that already paid in fear of losing their license, hence the effective date immediately. So if you turn over to the amendment, is on page 2, and all we're doing is we're truly clarifying that this is for a sole proprietorship, because proprietor is not in our statute. So for conforming consistency throughout, that's why we're putting that there. And then we're also clarifying, so it's crystal clear, we're adding the word company in front of licenses. And I ask for your aye vote for the amendment.
Question being called on the Standing Committee Amendment number 1. All those in favor, please say aye. All those opposed, please say no. Standing Committee Amendment number 1 has been adopted. We're back on the bill. Any further discussion?
And I would ask for your additional aye vote so we can get these people their money back. Thank you.
Question being called. All those in favor of Chairman Swanitzer's motion that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 76 do pass, please say aye. All those opposed, please say no. House Bill 76 has passed Committee of the Whole. Majority Floor Leader Summers.
Mr. Chairman, thank you. The next bills on Committee of the Whole will be 108, 89, 91, 15, 27, 54, and 82.
I'll repeat that for the body as well. Next bills are 108, 89, 91, 15, 27, 54, and 82. And with that, our next bill for consideration is House Bill 108. The reading clerk will read the bill.
House Bill 108, sponsored by Representative Hallinan. Funeral Service Practitioner Amendments, an act relating to funeral service practitioners. Mr. Speaker, your Committee Number 10, Labor, Health, and Social Services, to whom was referred House Bill 108, Funeral Services Practitioner Amendments, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Connolly, Flitner, Hallinan, LeBeau, Ottman, Stivar, Wharf, Wilson. Excused, Representative Romero Martinez. Representative Wilson, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Wilson?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, to do so with the recommendation that House Bill 108 do pass. There are no standing committee amendments, and I would turn the explanation of the bill over to the good doctor from the land of camels.
Representative Hallinan.
Thank you, Mr. Chairman. Due to COVID, I bring you House Bill 108 Funeral Service Practitioner Amendments. Due to COVID, our funeral service practitioners have seen a huge increase in their needed services. The overload, combined with the limited number of practitioners licensed in the state, has caused burnout and made clear the need to be able to recruit new practitioners. The purpose of the bill. Every state has different licensure requirements. The bill is attempting to align Wyoming's licensure requirements with more moderate standards in order to encourage experienced practitioners from other states to move to Wyoming. This bill changes the education and experience requirements for funeral service practitioner licensure in order to make it easier to find qualified individuals to come to Wyoming. It also addresses a minor change in the definition of embalming. This embalming definition, this change allows an unlicensed assistant to provide limited cosmetic services for identification purposes and disinfection through non-arterial methods. Education and experience requirements. It reduces the education for licensure requirements from 60 credit hours at an accredited college or university to allow for various educational choices. That includes an associate degree in funeral service practice or mortuary science, an applied science certification in an equivalent accredited program of funeral service education and mortuary service diploma combined with 5 years of experience. This bill reduces out-of-state and reciprocal licensure requirements. It allows 1, out-of-state practitioners and those from other jurisdictions who have equal or like educational requirements to be licensed. A waiver of apprenticeship requirements if the applicant is licensed and engaged in funeral service practice for at least 3 years. This is one of the most important items in the change. Current statute requires 5 years practice. Licensure from another jurisdiction that does not have formal licensing requirements to be granted a license if the applicant has at least 5 years experience and like education qualifications. So with that, Mr. Chairman, I would answer any questions, but if there aren't any, I would request that we would call the question.
Question being called. All those in favor of Chairman Wilson's motion that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 108 do pass, please say aye. All those opposed, please say no. House Bill 108 has passed Committee of the Whole. We are now on to House Bill 89. The reading clerk will read the bill.
House Bill 89, sponsored by Representative Greer, monthly ad valorem tax revisions enforcement, an act relating to mineral production. Mr. Speaker, your Committee Number 9, Minerals, Business and Economic Development, to whom was referred House Bill 89, monthly ad valorem tax revisions enforcement. Respectful report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Baer, Burkhart, Duncan, Ayer, Greer, Heiner, Sherwood, Western. Noes, Representative Gray. Representative Greer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Greer?
Yeah, thank you, Mr. Chairman. I move that when the Committee of the Whole rises reported, do so with the recommendation that House Bill 89 do pass. I'll further move the Standing Committee Amendment number 1. And just a brief comment in terms of this bill with the Standing Committee Amendment is supported by the industry that this bill is regulating. And then the Standing Committee Amendment basically rewrites the bill. Well, it didn't rewrite it, but it is the bill. So with that, Mr. Chairman, I'd like to turn the explanation of this over to the distinguished gentleman from House District 40.
Representative Crago.
Thank you, Mr. Chairman. So as we look at this bill, really it's a complementary piece of legislation, sort of follows up on what we've been dealing with over the last few years regarding ad valorem taxes in the mineral industry, oil and gas particularly. And so what this bill does is it piggybacks onto the back of that and really gives us an enforcement mechanism to collect these taxes that we've been working so hard to get corralled around and into a different venue and make the whole system cleaner. The current system provides for liens, but it doesn't really provide for a way to enforce those liens without protracted litigation. And during that time of protracted litigation, your minerals are flowing out of the ground, gone forever, the taxes are then not collectible. And what this bill does is simply allows the agency that conserves our oil and gas assets within the state to have a mechanism to collect that. And if you look at the amendment, the standing committee amendment, what it really does is it gives this long time, gives a 120-day notice period really to the producers. On top of that, then they get a hearing at the commission, which is probably another 45 days. And after that 45 days, they probably have another 30 days to cure. So it's a very long time period for the producers to come into compliance with the taxes before anything happens. The other thing the amendment does is also roll in severance. That was at the request of the agency that handles our revenue, so that they could deal with both of them at the same time, because now under our new system, they're collecting both those taxes at the same time. And this way they could just deal with it. Instead of piecemeal, they can deal with it all at the same time. So I'd ask for an aye vote on the amendment and an aye vote on the bill, and then stand for questions.
Question on Standing Committee Amendment number 1. All those in favor, please say aye. All those opposed, no. Standing Committee Amendment number 1 is adopted. Any further discussion on the bill? Question. All those in favor of Chairman Greer's motion that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 89 do pass, please say aye. All those opposed, no. House Bill 89 has passed Committee of the Whole. The next bill for our consideration is House Bill 91. The reading clerk will read the bill.
House Bill 91, sponsored by Representative Greer. County officers' salaries, an act relating to counties. Mr. Speaker, your committee number 2 appropriations, to whom was referred House Bill 91, county officers' salaries, respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Kenner, Larson Lloyd, Nicholas, Schwartz, Simpson, Stith, Walters. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure, Vice Chairman Larson?
Thank you, Mr. Speaker. Mr. Chairman, I move House Bill 91 and ask for your favorable consideration, and would turn the explanation over the bill to my good friend from the land of the great chief.
Chairman Greer.
Thank you, Mr. Chairman. I will also move Standing Committee Amendment number 1 and discuss everything together. Again, if you'll recall at introduction, this deals with the county officers. So these are people in the courthouse. I was primarily focused on the sheriffs, who had, the chief law enforcement officer of the counties. So this is very similar with the county attorneys in terms of, by our Constitution, the legislature shall set the salary, which has been deemed to be a cap is fine, or a range. Now, all of these salaries are paid by the counties. What they're asking for, in particular, was with the sheriffs, but the statute was so complicated, it was easier to include everybody and give the full discretion to the commissioners. But that the commissioners would set that salary. The cost rests with the counties. And so again, we get back to, a county with 1 or 2 municipalities, a lot of BLM, not many roads. That would describe my county very well. There's less work than, say, someone for another county that is much broader, with many more municipalities and towns and much higher population. And so the concept is meet the market, find out what is necessary for the qualified people. I know maybe one of the concerns here would be with some of the other offices in the courthouse, the clerks, the treasurers, the assessors, those types of things. Again, what I would ask is, move this bill forward. If you have a concern about one of those other ones, draft an amendment. I'm fine with it. My primary goal, so my goal is my commitment to support, and it was to the sheriffs. So the standing committee amendment took, what I did was a broad number back up to the district court salary levels of 165. The appropriations committee moved that down to the circuit court level, which we now know is 145. And so that's the standing committee amendment, is that reduction in that cap. And if there's any questions on the standing committee amendment, I'll answer them. If not, I would call for the question on that.
Representative Washut on the amendment. Question being called on Standing Committee Amendment number 1. All those in favor, please say aye.
Aye.
All those opposed, no. Standing Committee Amendment number 1 has been adopted. We're back on the bill. Representative Washut.
I've been doing a little looking, and as I read the Constitution, with the duty of this body of the legislature to not only set but fix the salary of these officials, and the case law dates back to like 1943, before the language was changed. And so I'm not completely comfortable that this idea of a range of salaries being allowed for by this body complies with our constitutional mandate. As much as I would love to have the counties have some latitude here, I do have some serious constitutional concerns about whether we fulfill our obligations by setting a range of salaries available for officials.
Representative Stith.
Mr. Chairman, I would be interested to learn more about it. When I looked into this in some detail with respect to this provision of the Constitution, that because it requires us to fix the salaries of the county officers, including school officers, right? So that the legislature has thus far failed to do so. But I'm not aware that the Constitution has changed since that Supreme Court decision was decided a long time ago. I could be wrong about that, but I'm not aware of it. I think the obligation to fix the salaries has, that language I think in the Constitution has remained the same. Could be wrong, but I think it is constitutional to set a minimum and a cap.
Chairman Zwanitzer.
Thanks, Mr. Chairman. And so one of the things that bothers me the most about our current wages between our statewide electeds and our counties are, as I said earlier, so many of our county employees, I shouldn't say so many, but more than 20 make more than our statewide electeds. So even with a circuit court judgeship, I think that's 145. And so we could have county-wide officers making more than our, even if the other bill goes through on the statewide elected salaries, I think that caps at 140 right now. And so we could legitimately have county officers making more than our chief executive and our other 4 statewide elected officials. Was there any discussion regarding that via the other bill on trying to merge them into something more coherent?
Chairman Greer.
Just briefly, and with the gentleman from Casper, I did not see it that way. I'll visit with him and look into it a little bit more. That's all I can tell him. With respect to the other comment, it's sort of the 2 wrongs don't make a right. We have undersheriffs, and just like we've got deputy county attorneys and other officials, where the statute says that they'll be paid at a rate that's commensurate with the services they're performing, that make more than the elected official. So, this is one of those things. I look at this simply as a matter of local control. They're local, that's their dollars. I know within my county, I don't think this is going to change anything. But I also know in other counties, it's more expensive to live. And they have more problems than we do in ours, because we kind of live in this little blissful Mayberry setting where I'm from. So anyway, do what you think's right. I would prefer an aye vote. Thank you.
Chairman Nicholas.
Thank you. And on that issue, there are lots of situations where we, the legislature, are directed to do certain things in the Constitution, where we delegate that authority. So I think we have the authority to delegate it, because not every job is the same. And the idea that one size fits all, we have chosen to allow the counties to do that. And so we are fixing our duties to the counties on the precise number. So I really don't think it's that big of a constitutional hurdle.
Seeing no further discussion, question being called. All those in favor of Vice Chairman Larson's motion that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 91 do pass, please say aye. Those opposed, House Bill 91 has passed committee of the whole. Looks like we have some comments. No? Next bill. All right. Next bill for our consideration is House Bill 15. Reading clerk will read the bill.
House Bill 15, sponsored by Representative Summers. Political subdivision club liquor licenses. An act relating to alcoholic beverages. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred House Bill 15, Political Subdivision Club Liquor License. Respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Blackburn, Burt, Clausen, Duncan, LeBeau, McGuire, Roscoe, Swanitzer. Noes, Representative Ayer. Representative Swanitzer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Swanitzer?
Thank you, Mr. Chairman. I move in the committee of the whole rise to report it do so with the recommendation that House Bill 15 do pass. There is a standing committee amendment, which I would move at this time, which makes the bill effective immediately. I don't think there is any concern with that, so I would call for the question on the standing committee amendment before I turn it over to the good majority floor leader.
Question on the standing committee amendment has been called. All those in favor say aye. All those opposed, no. Standing committee amendment number 1 has been adopted. We're over to Majority Floor Leader Summers.
Mr. Chairman and members of the 66, I bring you House Bill 15 and ask for your favorable consideration. In 2021, the legislature passed Enrolled Act number 17, originally House Bill 13. Prior to July 1st, 2021, Wyoming Statute 125201G allowed for political subdivisions operating a club license on a golf course to subcontract the operations of the golf course, including the sales and service of alcohol, without transferring the liquor license to that subcontractor. Effective July 31st, 2021, Wyoming Statute 125201G was repealed. And due to that legislative action, my county no longer has statutory authority to subcontract the sales and service of alcohol at the county's golf course. My county does not want to transfer its liquor license for its golf course because restaurant contractors come and go over time, nor do they want to get into the restaurant trade. House Bill 15 simply allows a political subdivision to contract or subcontract any food and beverage service associated with its golf course to an individual or entity without having to transfer its club-limited retail liquor license, and it seemed well supported by the industry and by the agency. And Mr. Chairman, I would stand for any questions.
Minority Floor Leader Connolly.
Thank you, Mr. Chairman. Mr. Majority Floor Leader, I'm just curious. It seems like it's limited to just a golf course, and I'm curious why the limitation, or if there's any other entities. I'm thinking about baseball fields or soccer pitches or something like that that a community might have control over.
Majority Floor Leader.
Mr. Chairman, I'm not sure, but there's this specific law on club golf course, and I don't know, there might be others that were nipped in that statute, but I'm not sure.
Representative Yin.
Thank you, Mr. Chairman. So I'm fine with the intent of the bill. I think that makes sense. I'm curious on whether your county contracts out the operation of the golf course, because I don't want there to be any negative side effects, because some golf courses I know limit who can come and go, and it could a political subdivision subcontract their golf course out to an entity that limits who can access the golf course. And would this allow for that while still giving the benefit of a club liquor license? Thank you, Mr. Chairman.
Majority Floor Leader Summers.
Mr. Chairman, thank you. And it's really just about the restaurant and the liquor trade on the golf course. It's not about renting it out. And there are other counties got trapped in this, and the good department that runs the liquor laws, they kind of give a get out of jail free card this last year until there was time to clean it up, and this is the cleanup.
Vice Chairman Newsom.
Thank you, Mr. Chairman. I am on in support of this. We had a similar situation in our town, and it turned into a big legal mess for our golf course. And so I'm fully in support of this particular bill. Thank you.
Seeing no further discussion, question being called. There we go. All those in favor of Chairman Zwanitzer's motion that when the committee of the whole rise to report it, do so with the recommendation that House Bill 15 do pass, please say aye. All those opposed, please say no. House Bill 15 has passed the Committee of the Whole. Next bill for our consideration is House Bill 27. The reading clerk will read the bill.
House Bill 27, sponsored by Representative Fortner. Visitation rights, an act relating to public health and safety. Mr. Speaker, your Committee Number 10, Labor, Health, and Social Services, to whom was referred House Bill 27, Visitation Rights, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Flitner, Hallinan, Ottman, Stivar, Wilson. Noes, Representatives Connolly, LeBeau, Romero Martinez, Wharf. Representative Wilson, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Wilson?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with the recommendation that House Bill 27 do pass. Mr. Chairman, there is a fairly large standing committee amendment, but I think it would be better to have the sponsor of the bill explain the bill first as it came to us and then circle back to me for the standing committee amendment. So if that's all right with you, I would turn the explanation of the bill over to the gentleman from House District 52.
Madam Chairman, so you will be explaining or moving the amendment later, is that right?
Yes, sir, if that's
That works,
okay.
thank you. Representative Fortner.
Thank you, Mr. Chairman. House Bill 0027 deals with visitation rights. It's an act relating to public health and safety, establishing visitation rights and providing for an effective date. Notwithstanding any other provision of law, a healthcare facility shall allow visitation for a person receiving care in the facility for a period of not more than 5 days or consecutive days. The healthcare facility shall not impose restrictions on visitation under this section. The healthcare facility shall allow the person receiving care of that person's representative to designate persons as visitors or to prohibit some or all visitation under this section.
Chairman Wilson.
Thank you, Mr. Chairman. I guess that was a sign for me to pick up the standing committee amendment. So, folks, most of us were pretty enthusiastic about this bill. We've all seen during COVID, most of us had situations where, hopefully it wasn't us, but family members, friends who were in the hospital, in nursing homes somewhere, and we couldn't see them. My own mom passed away in assisted living unvisited, so we knew the situation well. So what we did, though, with the standing committee amendment is try to find a place that makes this work for all of us who might be patients or visitors, and yet be cognizant of the situation that healthcare facilities would find them in. So if you look at the standing committee amendment, and I'm going to divide it for purposes of explanation. I'm not dividing it to make these as a motion. I'm not sure that it is because of, but it's the way it's typed up is kind of a long thing that at this time of day is a little hard to read. So if you look at the standing committee amendment, lines 5 through 12 put in a definition of healthcare facility, because when we looked at the original bill, in that section of statute, there's a lot of definitions of healthcare facility, and healthcare facility was 4 lines long, and that didn't seem to get at what the bringer of the bill was trying to do. So you'll see that the amendment there says that a healthcare facility that normally provides 24-hour per day care, including, and then we extracted from the statutory definitions, hospice, hospital, intermediate care facility, nursing care facility, psychiatric care facility, residential rehab facility, or assisted living. In other words, more or less nursing homes and hospitals. Then it goes on, line 13 through 17, and this dates back to my days as a candy striper when I was passing out pitchers of water, and there is a prisoner who was in the hospital there getting, and it came to me that if it so happened that a person who was a prisoner or, in some situation like that and say broke his leg and was in the hospital, we wouldn't actually want to open that up such that, all of the guy's favorite drug mules could come in and bring him flowers or something. So that just deletes or says that the section will not apply to people's involuntarily detained under Title 25 or adults convicted and in the custody of the state or local jurisdiction. Then lines 17 through 23, and you can imagine we had some discussion, and this is certainly a broad discussion that will send you back to your the days in special session, trying to find a compromise position here. We have said that the facility may impose and enforce restrictions on visitation that limit the number, the age of visitors, limit the location or time. In other words, maybe they have to meet in a special room or only between 10 a.m. and 3 p.m. I mean, most of us have visited people in healthcare facilities and recognize that that can be beneficial. Going on, require protective equipment or impose requirements otherwise required by regulatory agencies. And certainly you all will know that that last bit of the sentence has been the most difficult to deal with. We have, however, seen since we were in special session that the Supreme Court decided for us that the agency that supervises Medicare and Medicaid may make certain requirements, and we had, at least most of us in the committee, had no desire to put the facilities between state and federal law. Then at the end, to kind of make sure that people weren't just trying to blame somebody else, we said that the healthcare facility shall provide a written copy of its visitation policy to every person admitted or his representative, and shall visibly post in the facility a copy of the most current regulatory guidance that imposes visitation restrictions. And that, again, was due to, people tend to call me. So they're not even from my district, and they call me. I had a lady call me before Christmas, and she said that her mother's nursing home had told her that she couldn't bring in a poinsettia, that it was due to regulations. And I said, I'm not really sure that that's a regulation. So I connected her there, and I have to admit, sometimes people just make stuff up and tell you it's a regulation just so they don't have to put up with it. So we put in that line so that if they're going to limit the visitation and blame it on a regulation, they have to at least post the regulation so the visitor can see exactly what the situation is. So, Mr. Chairman, I'm not sure, did I move? If I didn't move, I do move Standing Committee Amendment number 1 and ask for your consideration, and I would be glad to take any questions.
Any questions on the amendment? Representative Olson? Chairman Olson?
Thank you, Mr. Chairman. I've got a couple of questions. And this was probably covered in the committee, but searching through just quickly, I couldn't find anything in statute where we currently impose restrictions. I don't know if there's something at the federal level where there are restrictions. And if there are, my question is whether we align with those or not. And the second question is more specific to the language on line 17, 18, 19. The healthcare facility may impose and enforce restrictions on visitation that limit the number or age of visitors. So is it reasonable that that could be construed to limit the number to 0? And as for the age, would this allow a facility to restrict age? I mean, what I think about is minors, but this statute appears to allow that hospital to limit it for any age. It could be if you're over 60, you can't come in. If you're between the ages of 30 and 50. So I just want to know if that's the purpose, or if it really is to limit it to minors. And those are my questions. Thank you, Mr. Chairman.
Representative Sweeney?
Thank you, Mr. Chairman. I have a very similar question on line 17. Halfway in, it says the healthcare facility may impose and enforce restrictions on visitation that limit the number or age. So is the intention of that only on where it says right before that, this section shall not apply to persons involuntarily detained under 2510-109, or who have been convicted of a crime, is that in relationship to that, or is this just in general that the healthcare facility may impose and enforce restrictions?
Representative Banks?
Mr. Chairman, thank you. Just a quick question. I understand the reasoning behind it, and I'm fully supportive of that. But towards the very end, primarily the amendment where it asks if you have to post those regulations and obviously provide them to the clients. Does that also allow them to change those regulations, once you are admitted, if those regulations change down the road, if the corporate policy changes, can they update that and provide that to the clients, going forward? Or once they're sort of adopted, say 10 years ago, those have to remain the same policies going forward?
Chairman Wilson.
Thank you, Mr. Chairman. I'm glad you stopped there. I'm writing, but I might not have. Okay, going back. So as far as whether there are restrictions now, there is nothing in our current statutes about the ability to put restrictions. As there are, of course, as you might suppose, voluminous regulations on restrictions that come down from the federal agency that pays for low income and people, and we were provided a copy of that in committee, and they change actually by the week, sometimes even. I mean, not normally, I suppose, but during COVID they did. And frankly, that's why we put the statement about requirements imposed by regulatory agencies. Certainly some people wanted us to take on that battle, but the majority of us didn't want to. As far as the question on lines 17 through 21 about the ages and the number, our approach really was to provide a general statement there that would hopefully provide reasonable restrictions. We're a little bit, some of us have seen, say, an obstetric unit will often say, nobody under the age of 12 or something. I mean, a different facility might have a different age limit, maybe nobody under the age of 5. I don't think we want to try to write in statute something about ages that would be really different between a nursing home in Shoshone and a hospital in Casper. I mean, that would really be beyond what the facility, I mean, that should be the facility's I would think, reasonableness. The question about enforcing, the idea on imposing and enforcing, there was a concern in the committee that just saying that you can have restrictions without enabling the healthcare facility to say, look, we've asked you to not have 2-year-olds in here after hours. You're just going to have to take the child out. That's generally what we're aiming at. If they have a person come over from Rollins for an appendectomy chained to the bed, I don't visualize them personally escorting out untoward visitors. Probably they'll call the facility. We've not confined, restricted it too tightly. As far as the question about changes, certainly my thought would be, and I'm not the drafter of, well, I did write the amendment basically, but you know how LSO fixes those. I mean, I don't think it's reasonable to say you can never change your visitation policy. I mean, a person might be in a nursing home for 10 years. I don't see how you could say, and you can never change it again. Frankly, it didn't occur to me that I would have to authorize them that ability to make one and change one and put it into statute, but I guess I'm not a lawyer.
Vice Chairman Larson.
Thank you, Mr. Chairman. And to the good Chairman of Labor, I just want to make sure that I understand the essence of this amendment. And what it says is you cannot prohibit someone who's in that facility from receiving visitation. The facility, however, they can put some restrictions on who or how long, but they cannot prohibit visitation. Do I have that correctly in a nutshell?
Chairman Wilson.
Mr. Chairman, thank you. Yes, I don't think we actually used that word, but that is the intention. And I'll just also bring back what I believe the sponsor of the bill had, which is at the end of line 14 on page 1. It does also allow the person receiving care or their representative to designate persons as visitors or to prohibit some. So we're, you know, if the people say, well, we don't want my kindergarten class visiting, then that would be, that's up to them. The facility may impose some restrictions on age or number, but they can't just say, you're stuck in here forever in a box.
Representative Ottman.
Because the amendment is pretty much.
Yes, just to clarify, I am a co-sponsor on the bill, and the original intent was to provide accommodations and open up facilities so that they would feel comfortable making reasonable accommodations for people whose health was being really threatened by lack of visitation and human interaction. There's things, there's plastic shields to put up, there's, you know, accommodation in a small place. It wasn't to rewrite the rules or anything of any particular organizations. It was to help people to get extra health care by having that interaction, which has been proven to be very instrumental in keeping people well. Thank you.
Chairman Wilson.
Thank you, Mr. Chairman. And just to follow on that, if you look on page 1, lines 13 and 14, the concern of the committee as we brought forth this amendment was just that the original bill states that the healthcare facility, which was not defined, shall not impose restrictions. And we were concerned that, although that would be great, that was probably a step too far for good care for the person and also just compliance with what would frankly be necessary. So, Mr. Chairman, I don't want to take over management of the bill from the sponsor, but so that's the standing committee amendment. I'd be glad to take some more questions on that, but otherwise I'll call for the question.
Question being called on Standing Committee Amendment number 1 to House Bill 27. All those in favor, please say aye. All those opposed, no. Standing Committee Amendment number 1 has been adopted. We're back on the floor, back on the bill. Representative Fortner. Vice Chairman Larson.
So, Mr. Chairman and members of the House, this bill has huge implications. And really, we have to think this through just a little bit. I understand that if we have somebody who's in a healthcare facility that we want to visit them and we want to take care of them. On the flip side of that coin, you've got an industry or a provider there that has a liability to ensure the health and the well-being of the patients in that facility. And so if they're in their best judgment, if they feel that they need to put restrictions, we're saying you can't. We're saying you can put restrictions, but if they're saying, and take away whatever illness we have currently, but if there's a very contagious or infectious disease in this room, in the hospital room, and previously they've been able to say no visitors, we've just eliminated that. We're saying you can't do that. Now, recently, I had a good friend that ended up in the hospital over here, and I walked down one day to see him, and there were restrictions. And it was for my well-being as well as the others. So my question is if we pass this and we say you can't do that, then where does the burden or that liability fall if something detrimental happens or a disease, whatever the situation happens, that somebody else is infected? Or this isn't as simple as I want to go sit with my grandson or my grandmother and the risk that my grandmother might pass away because and I've not been able to say my last goodbye. I get that. That's real, and I think that that's valid. But I think that this is deeper than that. And I'm not comfortable with I'm not comfortable with where this bill I think could take us. I think that we're imposing some requirements here on the healthcare industry that on the inverse side we're expecting them to protect. So be careful.
Representative Oakley.
Thank you very briefly, and I haven't looked into it, but I do note that it also is referring to people involuntarily detained and adults who have been convicted of a crime and are in the custody of a local jurisdiction, but that doesn't mention, so that says convicted. We currently have, if this pertains to that, we have people not convicted, but being held on murders charges and various other significant charges, but this seems to only say that it would be refrained from people being convicted. And again, I haven't looked at it all, but there's some concern there.
Representative Nyman.
Thank you, Mr. Chairman. You know, there's, I've had a couple different discussions and seen quite a few of these opportunities to address this very visitation problem. And I'll just give you one quick scenario and then I'll be out of your way. There was a lady in my district up there that brought a story to me where she said that I've been watching my mother on a video camera in her room. And she says, and that's all I can do. And she says, I'm thankful to be able to do that because that's all they would allow at that time. But she said the irony was to me, and this is the story that she relayed, is she said, I see the nurse come into my mother's room, be able to hold her hand, be able to address her needs and things like that. And I'm watching on the camera as this lady goes in and attends to my mother. They said, and I can't do that. And she said, but what bothered me the most was the fact that about 2 hours after I had watched this lady on the camera with my mom, I was in Walmart, and she said she walked up next to me and bought celery right next to me at Walmart and went home to see her family. And she said, the problem that I have with that is what can I do? What is she doing that I can't do that would allow me to now go into that room, be with my mom? She said, I would allow them folks to drench me in Clorox. She said, if I thought I could actually go and physically touch my mom. She says, there's got to be something we can do to be able to reach them, because that same lady in that same room with my mom, who I can't go see, is standing next to me in a public square going home to her family and is going to go back to that facility and be back in that room the next day with my mom, but I can't. And so I think there's a lot of folks out there that have got a situation where they would be glad to work with any healthcare facility and go through the protocols that would be necessary to have that ability to touch someone and to be with them when we don't know how many days, hours, or minutes they might have left. And the last thing we saw of them in those situations was through a video camera. And so I think there's room here for facilities to be able to allow loved ones to go through some protocols and allow those same people to have that opportunity to have human touch when we don't know how much longer we have with that loved one. So I would encourage you to pass this, and if it needs to be massaged and worked, then we can do that. We're not wanting to try to put anybody in peril, but whatever those things are those healthcare workers are able to do, this lady would like to be able to do that, to be able to touch her mom. So on and for the bill.
Members, just a friendly reminder not to use proper names of businesses on the floor in our speeches. Chairman Wilson.
Thank you, Mr. Chairman. The answers on 2 questions there is, my seatmate is correct that the amendment previously, earlier in the week, had a phrase about a person charged or convicted. Thinking of exactly that situation, I was outvoted in committee, but I'd be certainly glad to have a second reading amendment on that issue. Then just back to the restrictions, and I think I can use the word Oz because that's not really that was a fictitious place, but you know, the great and horrible agency in Washington, D.C. that supervises this thing have partly regained their sense, if I may be that hostile. Some examples of their restrictions. So we put in there deliberately regulatory restrictions. It's a very long, well, this one is 16 pages. Now they say, facilities shall not restrict visitation without a reasonable clinical or safety cause consistent with, and then there's a federal requirement. And then it has, for example, therefore, a nursing home must facilitate in-person visitation consistent with applicable blah, blah, blah regulations. Failure to facilitate visitation at the time of the visitor's choosing, subject to blah, blah. Anyway, I'm not going to read it all, and I'm not allowed to, but that's exactly why the majority of us, at any rate, put that sentence in there, is because the great and horrible regulatory agency has got, I think, enough wording to protect people who have the clinical concerns.
Vice Chairman Larson.
I think the good representative from up around the northeast part of the state has, I couldn't agree with him more. I think that there ought to be accommodations, but that's not what this bill says. And I think that we need to work, and I think that our healthcare providers need to help us be able to do that. I mean, if my grandmother wants to be with her three-legged cat and I've not been able to bring that to her, and it's not a prohibited, I should be able to do that. However, this bill says you shall, therefore it prohibits the ability to say no visitors. I'm going to guess that each of us have walked into a hospital where maybe there's been an infant that's very sick or another adult that's very sick, and the room's closed, there's a tent that says no visitors. And what we've just said in this bill is you can't do that. You can put restrictions, but at the end, but up to the point of preventing any visitation. I just think that we have to really, I would encourage us not to do that.
Members, let's also make sure that we address the chair. And Chairman Olson.
Thank you, Mr. Chairman. So now it's, kind of slowing this down and having some time to study the language of this bill, since it is now virtually a new bill. I am a little concerned that it's possible that this language is actually more restrictive. That, the good prosecutor brought up some concerns about involuntary confinement, but let me get to the language here. So a healthcare facility that provides 24-hour care, etc., shall allow visitation for a person receiving care in that facility, period. Now, does that include a sex offender whose offense is against his or her 9-year-old child who is ill? Can a facility reasonably restrict that person's access to that child? Does it include a mother or a father who is under a protection order, temporary protection order, a permanent protection order for domestic violence against their spouse in the room, against the child, whatever it may be? So I'm concerned that that language is overly restrictive, because although we're talking about it in a medical context, that is absolutely not what it does. It does not allow the facility to provide restrictions for other means. At least that's how I read it, outside of a reasonable or rational healthcare basis. So I'm concerned that our statute now may go too far and have unintended consequences. So, Body, I don't know that means that we can't clean this up on a second or third reading. I'm sure a lot of the things we've been discussing can be cleaned up, but I just urge some caution here with this language, that we may have unintended consequences that we did not foresee as we drafted this bill through this amendment. So thank you, Mr. Chairman.
Any further discussion? Seeing none. Question being called. Thank you. All those in favor of Chairman Wilson's motion that when the committee of the whole rise to report it, do so with the recommendation that House Bill 27 do pass, please say aye. All those opposed, please say no. Chair is in doubt. All those in favor, please stand. All those opposed, please stand. This will be close. House Bill 27 has passed Committee of the Whole. Next bill for our consideration is House Bill 54. The reading clerk will read the bill.
House Bill 54, sponsored by Representative Larson Lloyd. State Parks Recreation Management Authority, an act relating to state lands. Mr. Speaker, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom was referred House Bill 54, State Parks Recreation Management Authority, respectful report, same back to the House with the recommendation that it do pass. Ayes, Representatives Banks, Flitner, Knapp, Newsom, Sweeney, Williams. Noes, Representatives Haroldson, Jennings, Winter. Representative Flitner, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Flitner?
Mr. Chairman, I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 54 do pass. And with the explanation of House Bill 54, I give you the good representative from House District 54. What are the odds? The good Vice Chairman of Appropriations.
Vice Chairman Larson.
Thank you, Mr. Chairman, and I'd just like to thank the body for that last bill and the conversation we had on it. I think it identifies, I think this problem needs to be fixed. I think we need to address it and appreciate the time on this very short time that we took to really consider the points of it. Currently, we have an increase of outdoor recreation, and where and what can we do with that? And in my community, we have a school section that's up close. It's in the foothills, and there's a lessee that runs cattle there about 45 days a year, and the locals use it a lot to mountain bike, ride horses, walk their dogs, three-legged cats, anything else that they can get along there, we find. And the problem is that they've kind of started to love it to death, and it's impacted the lessee's ability to graze, a lot of new trails being made, and the folks are recognizing that the lessee is just wonderful and allows them to do that, but sometimes it's just a problem. And so how then can, the question was, is there a solution? And working with state lands, state parks, we come up with a solution to put into place a mechanism that allows state parks to have a recreational lease for a specific recreational activity on state lands upon approval of state lands and the lessee, if there is a lessee that's there. And so it's a subordinate to that. We heard testimony in committee that we currently have in place special use permits on state land, and if it impacts the lessee, that then there's a fee or for loss of acreage or for days of use there. And we also heard from state parks that around the state, we have a number of state lands that this would be really beneficial to people to be able to better utilize, and then they could come in, better develop the resource for the recreational activity that is warranted there. And then we allow them in the bill to collect fees that then state parks could use to pay state lands, because state lands' mission is to use those lands for the highest and best use. And so then they would pay state lands the fee, so there'd be no loss of revenue back to the state. And then they could also use it to develop and maintain the trails or whatever activity that is. And then they would develop the plan, the two agencies along with the lessee and the special use permit on how to develop those resources. And we heard, in fact, I was in Ag Committee this morning, and the guy that we heard from in state parks again said that this just really provides them the ability to do things that are in state lands that they've not been able to do previously. So I'd ask for your support and happy to answer any questions you might have.
Minority Floor Leader Connolly.
Thank you, Mr. Chairman. Just a quick question. I'm just curious, how does the state get fees? Honestly, I'm familiar with the little booths where you pay, and I'm familiar on federal land where there are little boxes, but I'm curious about how the state will get the fees that you're talking about in the bill.
Thank you.
Vice Chairman Larson.
Thank you, Mr. Chairman. And Representative, that's part of the issue. The mechanics of this haven't been in place. And so they're going to have to develop that. And so how do they develop fees? Would it be, they're going to have to work through that. Would it be a fee on a bike to go on around that? Or is it going to be if you had a Via Ferrata, do we dare say? And it would be a fee to use that by a concessionaire. So I think it could be specific to the various use that's there, but not clearly defined. Fair enough.
Any further discussion? Question being called. All those in favor of Chairman Flitner's motion that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 54 do pass, please say aye. Enthusiastic. All those say no. House Bill 54 enthusiastically passes Committee of the Whole. Next bill for our consideration is House Bill 82. Reading clerk, read the bill.
House Bill 82, sponsored by Representative Wilson. Military discharge and benefits, an act relating to veterans' benefits and exemptions. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom is referred House Bill 82, military discharge and benefits, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Baker, Brown, Burkhart, Burt, McGuire, O'Hearn, Stybar. Noes, Representative Henderson. Excused, Representative Obermueller. Representative Burkhart, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Burkhart?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rise to report, it do so with a recommendation that House Bill number 82 do pass, and I turn explanation of the bill over to the good representative from here in the capital city.
Chairman Wilson.
Thank you, Mr. Chairman. Here I am, folks, again. You heard about this bill upon introduction, so I'll just go over it a little bit more briefly, but always glad to take questions. You will recall that back in the fall, the Commander-in-Chief directed all military members to get COVID vaccine, which I agree he has the perfect right to do so. I'm not arguing with that. But you also know that I have a lot of military folks in my family, and when I started hearing news accounts that it was potentially going to be a punitive discharge, basically. There was one military newspaper suggested it might be a court-martial. There was one from the Navy that was talking about dishonorable discharges. I started receiving phone calls. They weren't even my constituents, but they were your constituents from around the state saying that people had been called up for drill weekend and they had been told that they might face jail time if they didn't get vaccinated. So you can imagine that lit me up a little bit. And so I started working on a bill that acknowledges that the Wyoming legislature over the years has seen fit, because of our value and respect for our veterans, we have given numerous benefits and exemptions to our veterans, but it almost always says to veterans honorably discharged. And so I got to feeling concerned about military members who might have served, 10, 15, 18 years, numerous deployments, and would have continued on, say, to their retirement or their end of their term, except for this vaccine requirement. So I drafted a bill, and I'll get to the end. I drafted a bill to say that for the purposes of our Wyoming benefits, now just a reminder, we cannot affect what the federal government does. This bill in no way impacts the federal government's decision, how the person's discharge is coded, what happens to them with their federal benefits. That's not in our purview at all. But what the bill says is that for the purpose of Wyoming benefits and exemptions, a person who is discharged solely for refusal to take a COVID vaccine shall be considered honorably discharged. So it doesn't require any extra money because these are people who, in the ordinary way of things, would have continued on for their 2 remaining years or whatever it was and been eligible for the benefit then. Just a little bit extra, and I can answer a number of questions, but while this bill was in process, the national budget bill that comes out for the military, there was an amendment that says members of, and they specifically listed Army, Navy, Air Force, Marine Corps, or Space Force shall only receive an honorable discharge. Doesn't include the Coast Guard, and it's not clear to me whether it includes the Guard. So, and of course, as we all know and are dealing with this week, an amendment to the budget bill lasts for the duration of the budget, right? Just like here, same thing in the feds. So that could go away. We still have maybe 80,000 unvaccinated folks who have not been discharged yet. They're kind of hanging around. And I just want to continue to value and appreciate the decisions that we've made in the past, giving these folks certain exemptions, and I can explain them later if you like, who otherwise would have continued their good service, except for this particular issue, which, whatever your opinions on it, we have to acknowledge have been very divisive, especially in this state. And Mr. Chairman, I'd be glad to answer questions.
Representative LeBeau.
Thank you, Mr. Chairman. I have a question. How will we know if someone's discharge is solely because of not being vaccinated? How will we know that?
Chairman Wilson.
Mr. Chairman, thank you. And I think that's a really good question. And here's where I put something on the member. Now, they get, when the person is separated from service, they get a form which has codes on it, which frankly, your average county clerk or license plate person is not going to know what those codes are. So I'm intending to tell people, and you keep a paper trail. And the military branches are doing this on their own because there's a lot of back and forth between the members. They send you an email, come in for this. They send you another email, come in for this. They give you a counseling form. So my take is you keep that. If you want to get this kind of benefit from this bill, you have to show up with that paperwork. That's what I think. We seem to have a...
Representative Burt.
Thank you, Mr. Chairman. To answer the question, how do we know how someone's discharged? When a service member's discharged, they have what's called a DD 214. On that 214 has the discharge code. If it's an honorable, then it says all that. If it's other than honorable, or if it's anything outside of that, it'll have a code in there, and it'll say why they're discharged. Now, anybody that's discharged for anything other than honorable, they have to go through a series of counselings and paperwork and so on and so forth. So all that documentation will come with them. So if a service member is discharged with something general other than honorable, then they will have their paperwork that will identify why they were discharged, which would say for COVID or refusal of vaccine. When they have all that paperwork plus their 214, they go in for the benefits, it'll actually identify all that. Thank you, Mr. Chairman.
Any further discussion? Representative Romero Martinez.
And just briefly on the guard side, it's a Form 9, and it's the same thing as other form that was mentioned earlier, and it has similar codes and that could be read.
Just another reminder to the body, please make sure that we address the chairman before speaking to the body. Any other discussion? Question being called. All those in favor of Chairman Burkhart's motion that when the committee of the whole rise to report, it do so with the recommendation that House Bill 82 do pass, please say aye. All those opposed, please say no. House Bill 82 has passed the committee of the whole. Majority Floor Leader Summers.
Mr. Chairman, thank you. We're going to do a few more bills. So we're going to do 88, 123, and then 92.
Majority Floor Leader is in trouble with the Chief Clerk at this point. Again, for the members, we are going to be taking up number 88 next, then 123, then 92. So the next bill for our consideration is House Bill 88. And he's also in trouble with the reading clerk, so. Reading clerk, please read House Bill 88.
House Bill 88, sponsored by Representative Harshman. Name change notice publication of minors amendment, an act relating to civil procedure. Mr. Speaker, your committee number 1 Judiciary, to whom is referred House Bill 88, name change notice publication of minors amendment, respectful report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Crago, Larson, Dan, Oakley, Olson, Provenza, Rodriguez-Williams, Washit, Yin, Zwanitzer. Representative Olson, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Olson?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report it, do so with the recommendation that House Bill 88 do pass. And I further move the adoption of Standing Committee Amendment number 1. I'll explain the Standing Committee Amendment, which the essence of this bill, which I won't go into great detail so that the author can discuss it with you, but the essence of the bill is to remove the requirement of publication when you ask for a name change for a minor. The Standing Committee Amendment simply adds a qualifier to that, in that we will ask that you show good cause to a court before you can be relieved of the requirement to publish the minor's name change. And I'll take any questions on the Standing Committee Amendment.
Question on Standing Committee Amendment number 1 has been called. All those in favor, please say aye. All those opposed, no. Standing Committee Amendment number 1 has been adopted. We are back on the bill.
Oh, yes.
Chairman Olson.
Thank you, Mr. Chairman. And I will turn over the explanation of this bill to the representative from House District 37.
Chairman Harshman.
Thank you, Mr. Chairman. Members, I think appreciate the good work of our Judiciary Committee, and I think address some of the questions on introduction. So if there's no further questions, I'd just call for the question.
Question being called. All those in favor of Chairman Olson's recommendation that when the Committee of the Whole rise to report, it do so with the recommendation that House Bill 88 do pass, please say aye. All those opposed, please say no. House Bill 88 passes Committee of the Whole. The next bill for our consideration, if the reading clerk is ready, is House Bill 123. Reading clerk, please read the bill.
House Bill 123, sponsored by Representative Barlow. Mine reclamation, disposal of materials, an act relating to environmental quality. Mr. Speaker, your committee number 9, Minerals, Business, and Economic Development, to whom was referred House Bill 123, mine reclamation, disposal of materials. Respectful report, same back to the House with the recommendation that it do pass with the following amendment. Ayes, Representatives Baer, Burkhart, Duncan, Ayer, Gray, Greer, Heiner, Sherwood, Western. Representative Greer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Greer?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises reported, do so with the recommendation that House Bill 123 do pass. Mr. Chairman, I'll also move Standing Committee Amendment number 1 to House Bill 123. Members, the Speaker got a 9-0 vote out of the Minerals Committee, so we're looking out for him. We did have a good discussion, and I think there's a little more work to come on this bill, and it'll be some good work, which when the bill is explained, I'm sure the Speaker will go through. In the meantime, the committee made a slight amendment, and that amendment is on page 2, lines 19 through 23, going over to page 3, lines 1 through 9. If you'll recall, we authorized the State Department Oversees Environmental Quality to take steps with the Office of Surface Mining and the SMACRA rules to allow wind turbines to be placed, basically backfill in coal mines. That is still in process. It is a relatively slow process, but it's moving along nicely. This bill had set a fee, as the bill's explained, for other inert items. And in the interest of keeping the fees the same, the fee for the wind turbines was changed. That would cause an additional delay in getting that approval from the Office of Surface Mining. And so the committee moved to strike that out and not mess with the work that we have done before, and then to allow this bill to continue to get worked by the process. So if there's any questions on that, I'd be more than happy to answer them. If not, I would ask for a aye vote on the Standing Committee Amendment.
Any discussion on Standing Committee Amendment number 1? Question being called. All those in favor of Standing Committee Amendment number 1, please say aye.
Aye.
All opposed, no. Standing Committee Amendment number 1 has been adopted. Back to the bill, Chairman Greer.
Yeah, then, Mr. Chairman, I'll turn the explanation of the bill over to the Speaker.
Speaker Barlow.
Thank you, Mr. Chairman. So members, I think this is a pretty straightforward bill. This just takes what we did in 2020 and expands it. So you'll recall House Bill 129, those over here, we took wind turbine blades and towers and we could place them in coal mines as backfill. This takes it to other materials and place them in non-coal mines. There's a particular company in my area, this is a constituent request, that's what we do, come down here, and they'd like to take and grind tires and place them in bentonite mines, in bentonite pits, old bentonite pits. Why is that important? Because tires take up a lot of space in our municipal landfills, and who's paying for that? We are. So they're going to try to make an enterprise out of this, clean up some of these places that have tires stacked up because they don't want to put them in the pits, and do this. So this bill does that. Now, thank you for the work of the Minerals Committee. That's why they scored themselves 9-0. That was a score. They did the good work, and that's great. But there's still a little more work to be done to clean up the definition of inert materials. So we're going to make it more application specific. Instead of this big, it'll be put in an application for a particular type of material, and the department will analyze that material, whether it's appropriate or not. So members, there will be a amendment on a succeeding reading, but for now I'd stand for any questions and ask for your favorable consideration. Thank you, Mr. Chairman.
Any discussion? Seeing none and question being called, all those in favor of Chairman Greer's motion that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 123 do pass, please say aye. All those opposed, no. House Bill 123 has passed Committee of the Whole. The next bill for our consideration is House Bill 92. The reading clerk will read the bill.
House Bill 92, sponsored by Rodriguez-Williams. Abortion Prohibition Supreme Court Decision. An act relating to abortion. Mr. Speaker, your Committee Number 10, Labor, Health, and Social Services, to whom is referred House Bill 92, Abortion Prohibition Supreme Court Decision. Respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Flitner, Hallinan, Ottman, Romero Martinez, Stivar, Wharf, Wilson. Noes. Connolly and LeBeau. Representative Wilson, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Wilson?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 92 do pass. There were no standing committee amendments, and I will turn the explanation of the bill over to the good member from House District 50.
Representative Williams, Rodriguez Williams.
Thank you, Mr. Chairman. I move House Bill 92 to Committee of the Whole and ask for your favorable consideration. Mr. Chairman, I won't go into great detail about this bill as we did during introduction, but just as a reminder, this bill is essentially a piece of legislation, if enacted, that would ban abortion if the Supreme Court overturns Roe v. Wade. This bill would put Wyoming in with several other states who already have legislation in place to protect the unborn upon the reversal of Roe v. Wade by the Supreme Court. And I'll stand for any questions.
Chairman Swanitzer.
Thank you. I just figured we'd probably have some questions on, I don't know, pretty significant shift of policy in Wyoming after 50 years in a budget session with no standing committee amendments. So probably some discussion warranted. First question, I guess, and the question that bothers me the most is in subsection B, we're preserving the woman from a serious risk of death or substantial physical impairment, but not including any psychological or emotional condition. So if a female is raped, she has to carry that child to term under the way this law is going to read, even if she has psychological or emotional distress throughout that entire pregnancy. That's a fairly significant shift in our current laws, I would say, if this goes through. And so I guess I would like that addressed first and foremost. We'll just start there.
Minority Floor Leader Connolly.
Thank you, Mr. Chairman. On and against this bill, try to follow the reasoning of this bill. And you all know that I am pro-choice. But regardless of that, I am just trying to follow how this would actually work in Wyoming and then what the precedent that would be set in terms of following this bill, which has in it that we will act, well, actually, it's not even the we, that once the Supreme Court acts in a particular way, and that's regarding Roe versus Wade, so it's a ruling regarding Roe versus Wade and waiting, at that point, our Attorney General takes a look at that ruling and makes a determination about whether a statute that we had on the books, which is A, should be overturned, and then subsection B go into place. Can you imagine that? I mean, honestly, the statutes are ours. Legislation is ours. What are in those green books? That's our responsibility. What this bill says is that, oh no, right? The Supreme Court says something, we're going to turn it over to an executive branch appointee to take a look at it and make a decision whether or not to overturn something that we have decided on as a body and put something else in without any more specificity. I can't fathom us doing that. It abrogates all of our responsibility as a legislative body, regardless of the subject matter, regardless of the subject matter. I can't imagine that we want that. Thank you.
Representative Rodriguez Williams.
Thank you, Mr. Chairman. In regards to the good representative that spoke first, to answer his question, differences of size, level of development, environment, and degree of dependency are not good reasons for saying you could be killed then, but not now. And I posed a question to the committee that asked this same question, and I'll pose it to the body here. Is someone's life really worth less than anyone else's because of the way that they were conceived? Addressing the good minority floor leader's question that she posed, there are a wealth of cases holding that the state legislature may make a law go into effect upon the occurrence of future contingent events. More specifically, a state may make implementation of a statute turn on action by the United States Supreme Court, as several states have done in other areas of the law. And to date, 11 states have enacted laws that would prohibit abortion upon the overturning of Roe v. Wade. Continuing on, a law that would take effect upon the action of third parties, in this case, the Supreme Court by overturning Roe v. Wade, does not constitute an improper delegation of legislative power, so long as the legislature has determined what action that is. A law prohibiting abortion that would take effect upon the overturning of Roe v. Wade would not delegate to the Supreme Court or any third party the authority to define conduct as criminal under state law. It would have been in the Indiana General Assembly itself that made that decision. So there is case law out there. Thus, there's no delegation of legislative power in such legislation. I stand for further questions.
Representative Sweeney.
Thank you, Mr. Chairman. So my question, just because 11 other states have done this means we need to do it, is what you're saying. But further, I just ask you, is this for our Constitution, Wyoming, not Indiana, not Texas, the rest of the states, the 11 states. With our Constitution, which we've heard a lot about in different discussions on constitutional, and I'm not an attorney, I'm not a constitutional scholar as other folks claim to be in the body, but is it constitutional, what you're proposing here?
Representative Romero Martinez.
Thank you, Mr. Chairman. I rise in support of this bill. I wanted to make a couple of comments in regards to the shift in policy and also in relation to the implications of psychology. 1 in 3 women have an abortion in the United States. That means everybody in everybody's family has someone in their family who has had a procured abortion, not a spontaneous abortion. Thus, every one of those women, regardless of the situation, automatically has an average of 10 years of post-traumatic stress disorder. In relation to all family members that are around, let's say it's your sister, is therefore post-abortive. What does that mean? It means that the stress, the anger, the violence that comes out is then expressed within a domestic situation. Since that was not mentioned, I wanted to mention that. What we're dealing with is a situation in our country where we now have the statistics and information to this nature that is extremely sad, unfortunately, because of approximately 50 years of Roe v. Wade, which doesn't abrogate anything. If anything, the courts decided for the first time in U.S. history to do the job of the Congress or to do the job of the legislature. This is an amazing bill because it's forward thinking. It's not in waiting. It's forward thinking in preparation for a Roe v. Wade overturn. Roe v. Wade may not be overturned, and the courts may give the jurisdiction back to the states. That's a likely scenario. But if they do overturn it, this bill is forward thinking. The good representative from House District 1 had a similar bill last year. I suggested a similar concept during the interim topic. It's not that we should follow what other states do. It's annotating the movement. It's annotating the movement of a life-affirming society. People look to the United States of America, if I could say that, or to our country for leadership. And unfortunately, for 50 years, we've led in the wrong direction. Further, minority communities, who many claim to be the spokespeople of, have not been speaking on our behalf. If you want to know the values of the Latino community, don't ask a white person. If you want to know the beliefs of the Latin culture, period, ask us. Ask our leaders. And don't go after the ones that were brainwashed and targeted in what has become a legal form of genocide. This is a life-affirming bill. It's amazing. Support it. Thank you.
Reminder to the members to please stay on topic of the bill. Representative Yin.
Mr. Chairman, thank you. You know, I've heard the same section of the Constitution, our state constitution, quoted over and over and over again this year, so many times. Article 1, Section 38, right of healthcare access. Each competent adult shall have the right to make his or her own healthcare decisions. And even in subsection D, the state of Wyoming shall act to preserve these rights from undue governmental infringement. So are you telling me that we're going to pass a bill where a woman is raped and she has no recourse with her own health care, with her own body? I think that's a real problem, and I do think that that's a significant departure, and I'm a little frustrated that we're debating it at the last bill this late at night where we're all kind of exhausted. So before we make something law where we affect the lives of so many people in our state, I think we just need to take a breath and think about what this will mean to your surrounding families, your community, to say that, you know, you have to bring that baby to term, no matter what. And I think that's really distressing. So I'll ask you to vote no on this bill. Thank you, Mr. Chairman.
Representative Roscoe.
Thank you, Mr. Chairman. One of the hardest decisions that someone's going to have to make in this case, I think, should be decided by that person's doctor, by that person's pastor, by that person's family. I don't think that decision is for us to make. Thank you, Mr. Chairman.
Representative Rodriguez Williams.
Thank you, Mr. Chairman. Just to address the question from the good representative from District 16 and District 58. That question was posed in the introduction of bills, and I'll just give you a gentle reminder that Article 1, Section 2 of the Wyoming Constitution guarantees the inherent right to life, liberty, and the pursuit of happiness. All members of the human race are equal. We know that babies in the womb are living human beings. Non-living things cannot develop into living things. That clearly defies the laws of science. Abortion is not healthcare. I ask for your favorable consideration. Move this bill forward. Thank you.
Any further discussion? Question being called. All those in favor of Chairman Wilson's recommendation that when the Committee of the Whole rise to report it, do so with the recommendation that House Bill 92 do pass, please say aye. All opposed, please say no. House Bill 92 has passed Committee of the Whole. Majority Floor Leader Summers.
Mr. Chairman, I move that the Committee of the Whole rise and report.
You've heard the motion. All those in favor, please say aye. Enthusiastic. All those opposed? The motion passes.
Reading clerk, read the Committee of the Whole report.
Mr. Speaker, your Committee of the Whole, having had under consideration bills on general file, begs leave to report as follows. House Bill 73, do pass. House Bill 63, do pass amended. House Bill 96, do pass. House Bill 83, do pass amended. House Bill 55, do pass amended. House Bill 117, do pass amended. House Bill 125, do pass amended. House Bill 62, do pass amended. House Bill 31, do pass amended. House Bill 56, do pass amended. House Bill 60, do pass amended. House Bill 10, do pass amended. House Bill 18, do pass. House Bill 5, do pass amended. House Bill 146, do pass. House Bill 131, do pass amended. House Bill 81, do pass. House Bill 110, do pass amended. House Bill 76, do pass amended. House Bill 107, do pass. House Bill 108, do pass. House Bill 89, do pass amended. House Bill 91, do pass amended. House Bill 15, do pass amended. House Bill 27, do pass amended. House Bill 54, do pass. House Bill 82, do pass. House Bill 88, do pass amended. House Bill 123, do pass amended. House Bill 92, do pass. Representative Brown, Chairman.
Chairman Brown.
Mr. Speaker, I move the adoption of the Committee of the Whole report.
Ladies and gentlemen, 30 bills. You've heard the motion. All those in favor, please say aye. All those opposed, no. Congratulations. We have set a new land speed record. Delirium sets in on the floor of the Wyoming House of Representatives. Well done, members. I know that was grueling. I can tell you it was just as grueling, or maybe twice as grueling, for the Majority Floor Leader. So give the Majority Floor Leader a hand, because that's all the accolades he possibly could need. All right, Committee of the Whole, committee reports.
House Bill 85, sponsored by Representative Oakley, child endangering, controlled substance use while pregnant, an act relating to crimes and offenses. Mr. Speaker, your Committee Number 1 Judiciary, to whom was referred House Bill 85, child endangering, controlled substance use while pregnant, respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Crago, Larson Dan, Oakley, Olson, Rodriguez Williams, Washit, Swanitzer. Noes. Representatives Provenza and Yin. Representative Washit, Vice Chairman. House Bill 11, sponsored by Select Tribal, Livestock Infectious Disease Control Tribal Inclusion, an act relating to agriculture. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom was referred House Bill 11, Livestock Infectious Disease Controlled Tribal Inclusion. Respectful report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Clausen, Eklund, Bortner, Heiner, Larson Dan, Western, Wharf, Winter. Representative Blackburn excused. Representative Eklund, Chairman. House Bill 136, sponsored by Representative Eklund. Underground water contested case hearings. An act related to underground water. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom was referred House Bill 136, Underground Water Contested Case Hearings. Respectful report, same back to the House with the recommendation that it do pass. Ayes, Representatives Clausen, Eklund, Fortner, Heiner, Wharf, Winter. Noes, Representatives Larson Dan, Western. Excused, Representative Blackburn. Representative Eklund, Chairman. House Bill 44, sponsored by Representative Newsom. Mobile home and vehicle titles and transfers, an act relating to motor vehicles. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 44, Mobile home and vehicle titles and transfers. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Baker, Brown, Burkhart, Burt, Henderson, McGuire, Obermueller, O'Hearn, Stivar. Representative Burkhart, Chairman. House Bill 64, sponsored by Representative Brown, Vehicle Service Contracts, an act relating to the Insurance Code. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 64, Vehicle Service Contracts. Respectful report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Baker, Brown, Burkhart, Burt, Henderson, McGuire, Obermueller, O'Hearn, Stivar. Representative Burkhart, Chairman. House Bill 149, sponsored by Representative Romero Martinez. Human Life Equality Prohibiting Discriminatory Abortions, an act relating to abortions. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom was referred House Bill 149, Human Life Equality Prohibiting Discriminatory Abortions. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Flitner, Hallinan, Ottman, Romero Martinez, Stivar, Wharf, Wilson. Noes, Representatives Connolly and LeBeau. Representative Wilson, Chairman.
Thank you. Messages from the Senate.
Message 137. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 26, District Judge Positions, Authorization and Funding. Ayes 30. Message 138. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 47, Carbon Storage and Sequestrian Liability. Ayes 30. Message 139. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 48, 2022 Large Project Funding. Ayes 30. Message 140. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 53, Local Government Liability Pool Amendments. Ayes 30. Message 141. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 68, Decentralized Autonomous Organizations Amendments. Ayes 30. Message 142. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 102, Second Amendment Protection Act. Ayes 22, noes 8. Message 143. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 12, Airport Restaurant Liquor Licenses. Ayes 26, conflicts 4. Message 144, Mr. Speaker, the bill listed below failed to pass the Senate's third reading by the vote indicated. Senate File 99, Public Monies, Deposits, and Credit Unions. Ayes 14, noes 16. Sincerely, Ellen Thompson, Senate Chief Clerk.
All right, members, there are only 20 amendments for third reading approved. That means only 1/3 of the amendments are approved. So there are 60+ amendments total. So if you have not approved your amendment, and it's available to you, please do so. There are also numerous requests rather late in the day. I was responsible for one of those, so I take responsibility for that. But so tomorrow morning, prior to, it'll likely be 7:30, depending on what the majority floor leader makes for our convening time, which I anticipate will be 9:30. So 7:30, you have needed to have reviewed and responded to your drafting requests. So please ensure that is accomplished. A couple other announcements. Tomorrow we'll have one bill on third reading. I think it's House Bill 3, and then we'll go into the budget. But before we do that, we'll do second reading on the 30 bills that we had today. Anything that has an amendment or somebody wants laid back, we'll lay back. So if there's any bill that we took off committee of the whole today, majority floor leader is just going to have a list, and we're just going to lay them back in en masse. If there's something that can move forward that is not controversial, then we'll pass it on. So Monday we'll have a third reading. Does that make sense? We try to keep the process going. So if you have a small amendment to a bill, you don't worry about laying it back. But if you've got substantial things, we'll lay it back so you have 2 readings to work on those bills that were done on general file today. We'll have a very full day tomorrow, ladies and gentlemen. I don't know what we'll do for lunch, but it'll probably be a shorter lunch hour than usual too, so we can accomplish what we need to accomplish on third reading on the budget. So, Mr. Majority Floor Leader.
Mr. Speaker, and I think we'll also make an attempt at having a very small committee of the whole. Obviously, we read in some bills that are very important to a few people. And so if we can, we will have a committee of the whole prior to that third reading of the budget. And there's going to be 4 bills that I've got on the committee of the whole list. That's subject to change. They are 136, 44, 64, and 85. And Mr. Speaker, I move that the House adjourn until 9:30 a.m. tomorrow, the 25th day of February, 2022.
Committee announcements. Chairman Olson.
Thank you, Mr. Speaker. Your committee number 1, Judiciary, will meet tomorrow morning at 8 a.m. in our usual place of abode to consider 2 Senate files, Senate File 25, District Judge Positions Authorization, and Senate File 29, Liability for Governmental Healthcare Providers Amendments.
Thank you. Chairman Nicholas.
Thank you, Mr. Speaker. Your House Appropriations will meet at 7:30. I'm moving that up a half an hour. 7:30 to hear Senate File 57, 58, 59, and 98. And any referrals.
Chairman Wilson, Chairman Paxton, Chairman Harshman. Chairman Wilson.
Thank you, Mr. Speaker. Your committee number 10, Labor, Health, and Social Services, will meet tomorrow at 8 o'clock in our usual room to consider 3 bills. Senate File 23, Nursing Home Administrator Licensure, Senate File 24, Pharmacist and Pharmacy Tech Practice, and Senate File 101, Epinephrine and Naloxone Administration Authority. And Mr. Chairman, or Mr. Speaker, may I have a privilege of the floor while I'm at it?
Please do.
Thank you. Members, if you will also look at, some people are off the floor, so tell your friends, in your boxes somewhere, you will see an invitation to Leap into Leadership. We just want to give you a little advance notice so you could plan. As you know, every year, the Leap into Leadership has a training session for women who want to get suggestions and training on how to take up leadership in their communities. And all legislators, male or female or any other kind, are invited to come for the dinner on Monday night, the 28th. You'll see it in here, The speaker, we'll have three speakers this time, actually. It's going to be a fireside chat with three of our Supreme Court justices. The dinner is free for you guys, but you do need to RSVP so you can make your choice of chicken, steak, or salmon.
Chairman Paxton.
Thank you, Mr. Speaker. Your committee number 4, Education, will meet tomorrow upon noon recess, 15 minutes after noon recess, to consider one bill, Senate File 31, absenteeism and truism.
Chairman Harshman.
Thank you, Mr. Speaker. Your committee number 3 will meet immediately upon adjournment and within 5 minutes to finish up work on House Bill 147, and that will be in West 113 underneath the Senate chambers. Thank you.
Thank you. Chairman Zwanitzer.
Thank you, Mr. Speaker. Committee number 7, Corporations, will meet tomorrow upon noon recess. We'll probably get to Senate File 27, Dissolution of County Boards, and Senate File 49, Repeal of Specified State Boards. If we have the full 2 hours, we'll also do Senate File 74, Water and Sewer District Amendments.
Further announcements? Further announcements? Seeing none. Members, thank you for your hard work today. Members, we are adjourned until 9:30 a.m., the 10th day of the 66 Wyoming budget session, Friday, February 25th. We are adjourned.